Yes.
May I beg to mention the matter for extension of entry model?
Why you're sleeping all the days? Last
No,
moment
it's
you're coming.
subsisting. It's subsisting. Entry model is subsisting till 30th of May.
30th of May.
Or may I permit to mention a matter not see?
What?
Anticipated bail matter not see.
No. Next step.
CRR 132 of 26, CRR 133 extension of entry model.
Where is the mentioning list? Give the mentioning list. Yes, next. Call.
Item number 1, judgment.
The second appeal is dismissed. The judgment and decree passed by the additional district judge is affirmed. The appellants are directed to vacate the premises within 60 days, pending with the petitioner's liberty to put the decree in execution.
Item number 2.
Lordship, it is for correction, Lordship.
For what?
Lordship, one year has been typed in paragraph number 1, 2029. That would be 2020-19.
Huh?
In paragraph
MSCC 29, 2009. 2019.
2019. And Lordship, at paragraph 14, ADJ first code, that would be ADJ fourth code.
Huh?
ADJ first code, that would be ADJ fourth code. Para 14, Lordship. Judgment.
ADJ fourth court.
ADJ fourth.
The matter is listed as to be mentioned for correction in the order dated 13th May 2026. Learned counsel for the appellant. Insurance company.
I am for the appellate. His insurance company.
Counsel for the appellant submits that in paragraph number 1, line number 4, the MSCC case number is recorded as 323 of 2019 instead of 323 of 2029. 2029 instead of 2019. The counsel for the appellant further pointed out that with paragraph 14
and 1.
Paragraph 14, the matter is to be remanded back to the motor accident claim tribunal, fourth court instead of first. In view of the above, in paragraph 1, the MSCC case number shall be read as 323 of 2019 instead of 323 of 2029, and in paragraph 14, the court number shall be read as MSCC Tribunal, Motor Accident Claims Tribunal ADJ, fourth court, Jalpaiguri, instead of ADJ, first court, Jalpaiguri.
Lordship, for insurance company, another correction is required.
Huh?
For insurance company,
Huh?
liberty is required for
Learned
the
counsel for the insurance
statutory
company
deposit.
submit that at the time of admission of this appeal, the insurance company has deposited rupees 25,000 being the statutory amount, comma, the insurance company is given liberty to withdraw the same.
Grateful, Lordship.
This order may be read along with the order dated.
Advocate for the insurance company. Advocate for the insurance company.
Next. Item number 5.
Yes.
Insurance company.
Which for the petitioner? Now what is the state? None appears. Pass over.
Item number 6.
5 Union of India. 6 for the state.
6. 6 who is for the petitioner? What is the case? What is the matter? Under section?
Mr. Jagriti Misra is there actually.
What is the matter? What is the, what
My
is
lord,
the
this is a case under section 6.
6 of POXO?
6 of POCSO. The victim is also, he has been noticed was, we were directed to serve notice upon the
Yes.
Lordship, the allegation is
Yeah,
under
for the
section
defect to complaint.
351, subsection 369 and 77 of the BNS. Lordship, in this case, what has happened? In the month of December 2025, the victim, she is a married lady. She had some dispute with her husband. She voluntarily left her matrimonial house. And thereafter, she allegedly went to the house of the petitioner and stayed there for few months. And it is alleged that there the petitioner committed rape upon her with a promise to marry. And this incident took place in the month of December 2025, and this FIR has been lodged in the month of February after a gap of more than 3 months.
Sole accused.
So like
Where is the FIR?
FIR, Lordship,
In the Bangalore now, right?
is a Bengali.
I have the translated copy.
You are for the complainant?
Yes, my lord. Sixty-nine. ये comes to marry. আর rape দিয়েছে 76 সালে। এটার জন্য fingerprints করে কি করে এটার জন্য তো কাস্টডি লাগবে ইন্ট্রোডাকশন না
Yes, investigation.
My lord, she's a lady having a child. And the thing is that, my lord, his custody interrogation is required because he has taken certain photographs.
No, these are allegations, Lordship. Nothing has been.
Serious allegations, my lord. So this is the CD. Medical is there.
Why the police is not arresting the accused persons? 5 months, 6 months, 4
They're
months.
absconding.
Why?
Also, the incident is of December 2025, and
Correct,
this FIR has been lodged after 3 months, Lordship.
Correct.
Kindly consider that.
In this type of cases, my lord, FIRs are little bit delayed, my lord.
Lordship, if there is required, I am ready to cooperate, Lordship. Kindly consider.
The petition has filed the present application under section 482 of the BNSS 2023 for grant of anticipatory bail in connection with Rajganj Police Station case number 57 of 2026 dated 17th of February 2026 under section 351 within bracket 3/69/77 of the BNSS 2023. Police traffic. And counsel for the petition submit that as per the complaint made by the victim, the alleged incident was occurred in the month of December 2025, but the victim has made the complaint in the month of February 2025, that is after the period of 2 months. He further submit that the allegation made in the FIR is totally false and baseless. Police. It is the petitioner, the victim has made out a case of promise to marriage, but the victim is the married lady having the 7 years of old son. Police stuff. He submitted that there is no necessity of the custodial interrogation if this court will grant anticipated leave, the petitioner will appear before the investigating agents and cooperate with the investigation. Police. And counsel, the counsel appearing for the victim is present and she submit that the petitioner has committed the offense against the woman and has threatened the petitioner and threatened the petitioner. He has also taken the signature in some bond paper and also taken the photographs and threatened the victim that if he will not cooperate with the petitioner, he will publish the video in the WhatsApp group. The learned APP in charge is present along with the IU who presents the city. This court find that the allegation against the petitioner is severe in nature and several document and the WhatsApp messages is required to be WhatsApp and the photographs alleged to have been taken by the petitioner in his mobile phone is required to be seized. Thus, this court is of the view that the custodial interrogation is required. And at this stage, if the anticipatory bail is granted to the petition, there is every chance that the petitioner will hamper and tamper with the evidence. In view of the above, this court is not inclined to grant anticipatory bail to the petitioner. CRM A 261 of 2026 is dismissed.
I'm grateful, my lord.
ADB returned to the Grateful. Next.
Item number 8.
Yes, who is for the petitioner? EC Act.
Yes, my lord, yes, EC Act is there and other sections also there. Section 317, subsection 2, dishonest recipient, my lord. Section 317, subsection 4 of the BNS, habitual purchasing of habitual stolen property. And 317.3, that is assisting in concealment of stolen property. Total 7,600 liters of kerosene oil, my lord. Stored at the house of this petitioner.
Caesar made.
And my
Caesar
lord,
made.
my lord, Caesar made. Majinur Rahman, the petitioner.
Who is for the petitioner?
Mr. Shishandu Kumar Rai Basunia.
The petitioner has filed the present application under section 482 of the BNS 2023, praying for grant of anticipatory bail in connection with Tufanganj Police Station case number 109 of 2026, dated 22nd of February 2026, under section 7 within bracket 1 within bracket small a within bracket II of the EC Act 1955, read with section 303 within bracket 2/317 within bracket 2/317 within bracket 4/317 within bracket 5 of the BNS 2023, pending before the learned court of police. None appears on the petitioner. The matter was listed. The matter was listed on 8th of May 2026 on the prayer of the petition. The case was adjourned. In presence of the petitioner, this court has directed the investigating officer to present before this court with the case diary. Today, when the case is called, the IU is present along with the PP in charge and produce the case diary, but none appears on the petitioner. And thus, this court has no other option to take the bail application in the absence of the learned advocate for the petition. Full stop. The IU has produced the CD where full stop. The allegation against the petitioner is that on receipt of the information, the police has raided and has recovered 6 numbers of red plastic drums loaded with the kerosene oil, like petroleum product, each approximately 200-liter capacity, and 32 blue plastic drums loaded with the kerosene oil, like petroleum product, each about 200-liter capacity. Full stop. When the police has raided and seized the said materials, the petitioner failed to produce any document to prove that the petitioner is having the license to keep the petroleum product in the godown. Full stop. Since the initiation of the FIR, the petitioner is absconding. In spite of several efforts made by the police, the police would not trace out the petitioner. Consider the submission, consider the CD. This could find that the petitioner is absconding and the custodial interrogation is required, from where the petitioner has collected the said kerosene oil with petroleum product. Considering the nature of the offense, this court is not inclined to grant anticipatory bail against PRM circumstances dismissed. CD be returned to the IU.
Grateful, ma'am.
Next.
9,
Lordship,
Yes,
I am for the petitioner, Lordship.
yes.
My lord, 9 and 10, Passover, CD is on the way, my lord.
Okay, 9, 10 pass over.
Lordship, can it be placed before the next cycle, Lordship?
No.
Tomorrow you want? Tomorrow?
Why?
Lordship, kindly,
Lordship,
sure, I have been just informed to appear in this matter for the de facto complaint. Kindly, I am granting one-day accommodation. The brief is yet to be received.
Huh?
The brief is yet to be received.
Not today. 9 and 10, not today.
I'm grateful, my lord.
11,
10, man. It is not 10.
Ah.
For the petitioner.
10. Just somebody has to ask. Not
He's for
today.
9. He's for 9.
Mr. 10, you are ready?
10,
My lord.
so I'm praying for 10.
Yes,
Yes.
taking
Well,
time.
10,
Come to
One day
come tomorrow.
accommodation.
Next.
the service not affected, my lord.
Come tomorrow,
11.
come.
Yes, sir.
Who is appearing for 11?
My lord, this is the criminal antecedent he has on the last occasion also yesterday. My lord asked, so we have cases are pending, my lord.
One case.
My lord,
One
Raghunath, my lord. Kota cases? 2 cases are there, my lord, already. Inspire. This one along with another 2 cases, my lord, previous. So he is a habitual, my lord.
The petitioner has filed the present application for grant of anticipatory bail. Grant of anticipatory bail in connection with Pansi Deva Police Station case number 428 of 2025 dated 24th of September 2025 under section 20 within bracket small b within bracket II within bracket small c /29 of the NDPS Act. Full stop. The IO is present along with the case, PP in charge along with the IO is present. CD is produced, none appears on behalf of the petitioner. It is fine from the record, the petitioner is a habitual offender and the other 2 cases are pending before the court. And as such, this court is not inclined to grant anticipatory bail in respect of anticipatory bail. Full stop. CRS is dismissed. CTB returned.
Grateful.
12,
Yes. So endorsement.
Who is appearing?
Seal mere the endorsement. Money. My lord, this case, my lord, goes to the FIR. There was a temporary defalcation, my lord. He has withdrawn money from the bank and later on it was, my lord, returned, my lord. So it's-
3165.
My lord. কি বলেছে? Money. There was a my lord, misappropriation of government money to a tune of 1,14,000, my lord. Even if he returns that amount, my lord, the offense has been committed.
Where is the petition?
Had it been the punishment only, fine, that is a different thing. But where there is a punishment for imprisonment,
So how the FIR is lodged? In the complaint
the
itself,
customer has lost the complaints.
in the, kindly see the FIR,
My lord,
the entire defrauded amount has been credited by so and so into the government account, hence.
that I might tell, already the amount was withdrawn. So the means he has committed the crime. Now, when it came to the knowledge of the customers, when they complain, now thereafter he has returned that amount. Whether that will, in that case,
What is the total amount?
1,14,000.
The petitioner has filed the present application under section 482 of the PNS 2023 for grant of anticipatory bail in connection with Darjeeling Sadar Police Station case number 31 of 2026 dated 7th of March 2026 under section 316 within bracket 5 of the PNS 2023 pending before the Learned Chief Judicial Magistrate at Darjeeling. The police has registered the case on the basis of the written complaint of the Sub-Divisional Inspector of Post Offices on the allegation that the petitioner has misappropriated an amount of rupees
14,000,
1,14,000. Police, in the complaint itself, they respond that the defrauded amount, the alleged defrauded amount has already been credited by the petitioner in the government account. And it is also mentioned that no more recovery is required to be made from the office, from the petitioner. Full stop. In charge is present along with the IO. CD is produced. This court finds that the alleged alleged misappropriated amount has already been credited by the petitioner in the government account, and it is specific case of the complainant that no further recovery is required to be made from the petitioner. Thus, this court finds that no custodial interrogation is required. Full stop. In the event of arrest, the petitioner shall be released on furnishing bond of rupees 5,000 with one surety. Full stop. If on bail, he shall appear before the investigating officer till the report in final form is submitted by the court. CR is disposed.
13.
Okay, my lord, I'm for the petitioner, my lord. In this matter, my lord, NDPS case, my lord, and when my lord, 3 persons were arrested on NGP station in a running train, my lord. And thereafter, your petitioner's name, my lord, transferred from another accused. And surprisingly, the contraband article was seized from one lady's bag, my lord. And they brought ticket from a agent where three different person, my lord. They are one spinner. They're traveling.
You are also traveling with the.
No. I am not at the
Three
spot, my
persons were
lord.
traveling in the train.
No.
Ah.
I have no role, my lord.
Who are traveling in the train?
3 persons traveling in the train, my lord,
Ah.
and one pinner. They brought one pinner number.
3 persons were traveling.
But they are different, my lord. They don't know each other, my lord.
Correct.
And my lord, one lady's bag, my lord, the contraband article
Out
was
of 3 persons in one of the
My lord,
passengers, who is the lady passenger, from her bag, the contraband was seized.
I have seen, my-
Yes. that-
And my lord, another one is Suraj Mahato. He, my lord, was arrested.
Who?
With Suraj Mahato. Only
Ah.
for my lord, his PNR number are the same.
Acha.
Thereafter, my lord, police put his father name, my lord. I am from his father.
You are the father of the Mahato.
Father of the one accused person, my lord.
You are the father of the arrested accused
As
person.
one accused person.
Yes.
But he have no role. He reside in, my lord, Dimapur, Nagaland.
Hmm.
This is the case, my lord.
Hmm.
And he is, my lord, 62 years old, no connection with any criminal incident. He is by professionally a teacher, my lord.
Hmm.
This is the, my lord, entire case.
Hmm.
That's why, my lord, I am praying for his.
So why you have been arrested? Why your name has been added? Your name is added in the FIR.
My lord, my name is.
You are the FIR named
And
accused.
charge sheet, my lord.
The charge sheet is filed.
Charge sheet filed, my lord. Already.
Ah.
No role in my.
No role.
Any role.
Where is the charge sheet?
Charge sheet,
During the
my lord,
investigation,
page 14, my lord.
what is your name? Vishnu Prasad
Vishnu
Mahato.
Prasad Mahato.
Suraj Prasad, your son.
Son, my.
Nisa Singh, you don't know.
I don't know.
Ajay Chakravarti, Chaudhary, you don't know. Being collected from the Vishnu Prasad. It has been collected from you.
This is, my lord, allegation, my lord.
Yeah.
The transfer from, my lord, after arrested, my lord.
Hmm. Correct. Collected from so and so, so and so.
This petitioner is the mastermind, my lord. He is the kingpin.
What is the?
525 grams of brown.
My lord,
That's why.
this is, my lord, allegation, my lord.
Maybe. So you have to face the trial.
On the same case, my lord, your lordship, my lord, release, granted bail, my lord, from their.
Brown sugar.
No recovery from position, my lord.
Brown
And,
sugar.
no, my lord, and another case is, my lord.
Kindly see the facts of that case. I know. The second day I granted the bail.
No, another-
Kindly see that. Yes.
My
Can you
lord,
see?
another co-accused, another.
Yes, correct.
coordinate
Kindly
bench,
see
my
the
lord.
facts.
My lord, on 795 bottles of Cassia,
Ah.
my lord, from, my lord, they are not recovered.
This is brown sugar.
But another, my lord, coordinate bench also granted bail from, if no recovery from their position, my lord.
Hmm.
This is the case. If, my lord, any condition
But it's
can be.
brown sugar. I can't.
My lord, even coordinate benches has rejected the bail applications on the basis
Of
of
this-
the 161.
of this petitioner?
This petition, only, this is first application, my
Not in
lord.
this petition, in other cases also. But
This-
he is referring, my lord, what coordinate.
Other cases, my lord, but this case is
Because
first time application, my lord.
The petitioner has filed the present application for grant of anticipatory bail under section 438 of the Code of Criminal Procedure 1973. In connection with CR NDPS case number 761 of 2025 arising out of NJP GRPS police station case number 72 of 2025 dated 11th of October 2025 under section 8 within bracket C/21 within bracket C/29 of the NDPS Act 1985. Counsel for the petition submit that only on the basis of the statement of the co-accused, the name has been added by the investigating agency at the time of filing of the charge sheet. He further submit that nothing was recovered from the petitioner and there is no incriminating materials available on record to connect the petitioner in the present case. He further submit that it is settled law that only on the basis of the statement of the co-accused, the another accused cannot be entangled. Full stop. Full stop.
Learned, my lord, both the accused persons has given state. Both the accused persons has named this.
No, this person,
Yes, both the.
FIR. No, that's why, okay.
161,
Yes, yes.
Both the.
The Leonard Council, Leonard APP in charge along with the IO is present, produce the CD and submit that both the arrested accused persons have stated that the present petitioner has supplied the said narcotics to the arrested accused persons. He further submit that this petitioner is a kingpin, full stop. He further submit that there are several materials against the petitioner, and if at this stage if the petition is granted bail, the petitioner will naturally hamper and tamper with the evidence. Police. Heard the learned counsel for the respective parties perusing materials on record. This court find that it is the specific case of the prosecution in the charge sheet that both the arrested accused persons have stated that the petitioner has supplied the narcotics to the arrested accused persons. Police. Arrested accused person. This court find that the police has already completed the investigation and submitted the charge sheet, and as such, this court is not inclined to grant bail to the petitioner. CRM census is dismissed. CDB written.
Alright.
14,
My lord, one indulgence, my lord, on item number 8 and 11, my lord, I could not appear before your lordship, my lord. My lord, kindly hear me out, my lord. My lord, on any time, my lord. My lord, I was coming from Dhupguri, my lord, and stuck in jam, my lord.
I am coming from
Traffic.
the Andaman.
My lord, kindly, my lord.
I came from Andaman.
My lord, on any day, my
I'm
lord,
sitting
at least,
at
my lord,
10:30
hear me
here.
out, my lord. My lord, one.
Sorry,
My lord,
if you're an advocate, you be perfect in the time.
my lord,
If you're not perfect in time, you'll never be an advocate.
my lord, kindly, my lord, take up the matter on any
Sorry.
time, my lord.
Yes.
No time for the petitioner, my lord. Not allegation under section 21C 29 of the NDPS Act, my lord. Not no contraband has been seized from this accused petitioner, my lord. My lord, his name has been transferred from the principal accused, my lord. And my lord, co-accused is enlarged on bail, my lord, by the coordination.
Yes.
Co-accused is enlarged on bail, my lord, by
Work
this.
has been enlarged on bail.
Yes, my lord, by this coordinate bench. my lord.
What is the seizure? What has been seized? What is the
From the
narcotics?
264 gram of brown sugar, my lord.
Brown sugar, sorry.
Nothing has been seized from this petitioner, my lord.
Face the trial, go to the trial and find an application before the trial. How the anticipatory bail? The petition has filed the present application for grant of anticipatory bail under section 438 of the Code of Criminal Procedure in connection with New Kuch Bihar GP and New Kuch Bihar GRPS case number, GRPS police station case number 9 of 2025 dated 26th of March 2025 under section 21 within bracket small c /29 of the NDPS Act. On a counsel for the petitioner submit that the petitioner has been named in the charge sheet.
Yes, my lord.
The petitioner is not the named accused persons in the FIR, but only at the time of filing of the charge sheet on the basis of the statement of the co-accused persons, the name of the petitioner has been entangled. He further submit that nothing has been seized from this petitioner and petitioner is no way connected in the present case. He submit that the petitioner will appear before the investigating officer and before the trial court if the anticipated bail is granted. Learned counsel, Learned APP in charge is present along with the IU and the CD. This court peruse the CD and find that it is a specific case of the prosecution that the petitioner is equally involved in the matter, and the narcotics seized by the police is of the brown sugar. Considering the above, this court not inclined to grant anticipatory bail. CRM census is dismissed.
15,
My lord, I am for the petitioner in item number 15.
Yes.
I am praying for one-day accommodation, my lord, since there are few documents. There are few documents that needs to be filed, your honor, by way of supplementary affidavit to prove my innocence and my case, your honor. I'm just seeking one-day accommodation.
As per the prayer made by the counsel for the petitioner, let the matter appear
My
tomorrow.
lord, this case on the last occasion also, I was present with this case. Today also he is present. My lord, this is a case, my lord. My lord, already he has sold the land of another person. My lord. That is the complaint. And that person has been, all the documents of that original owner has been seized. He is the real owner of that property. In spite of that, this petitioner has sold the property of that land.
For that
Yes,
reason,
for the-
for
For
that
the last
reason-
2 days, sorry, for the last 2 days, the IU is appearing before this court.
Along with the original.
My
The
lord-
CD is present.
My lord, it was listed.
How the-
My lord, it was listed yesterday, but the matter was not called yesterday, and I have already made an application before the BLRO to supply me few.
DLR has already
Today,
given a report.
my lord.
So those documents
Just one
are
day
required to
accommodation,
consider this. Not required, my lord. Already BLO has given a report. How can BLO proceed his own report?
My lord, just 1 day accommodation, I'll prove my innocence and I will file the documents, my lord. Just 1 day, my lord.
Come to me.
I'm grateful, my lord. I'm grateful.
My lord, then it will be day after tomorrow.
Day
Because
after-
my lord, the CME is there, so that's why the CME is there.
Day after tomorrow.
Grateful, my lord.
Next.
16,
Day after tomorrow, ज़्यादा matter करेगा। सही है। Next, 16. Yes, who is for the 16? Item number 16. अच्छा। This court finds that by an order dated 5th of November 2020, this court granted bail to the petitioner. Bail to the petitioner. With the direction, with the condition that if on bail, the petitioner, the appellant shall meet the judicial officer in charge of the police station during the period of bail once in fortnight, and he will produce their present residential address by way of affidavit before the officer in charge of the concerned PS on the first date of their appearance. Full stop. It is also recorded that if the petitioner failed to comply with any of the direction, the order of bail shall be cancelled without any further reference of this court. Full stop. This court find that the paper book is ready, but none appears on behalf of the petitioner. In view of the above, the officer in charge, Darjeeling is officer in charge. Mr. I see. The IC, the in charge of PS Darjeeling. Yes, Sika Poka. Ki ache?
Sukhia Pokri. Sukhia Pokri is OC.
Sukhia Poka.
Sukhia Pokri is OC.
The OC of PS Sukhia Pokri. Pokar hai? Pokri is directed to submit report.
My lord wants to go to Sandrapur, then you have to go in Sukhia Pokri.
To submit report with regard to whether the appellant has complied with the condition of the bail order dated 5th of November 2020, and to produce the appellant before this court on 11th of June 2026. This is the matter on 11th of June 2026. The department is directed to communicate this order to the officer in charge of Sukhia Police Darjeeling for compliance. Next.
17,
Okay. Yes. You have a CD? You have a CD of item number 17? No. It is fine from the record for the several dates none appears on behalf of the petitioner. The matter was listed on 15th of May 2026. On the said date also none appears on the petitioner. For the interest of justice, the case was adjourned. till today with the rider that if on the date fixed none appears on behalf of the petitioner, the revision application will dispose of on merit. Today also when the matter is called, none appears on behalf of the petitioner, no accommodation is sought for. This court find that the petitioner has filed the present application being present application under section 482 of the Code of Criminal Procedure for quashing of the new Jalpaiguri police station case number 274 of 2023 dated 28th of March 2023 under section 363 of the 365 of the Indian Penal Code pending before the London Court of Chief Judicial Magistrate at Jalpaiguri being GR case number 1503 of 2023. This was considered the FIR and find that a specific case has been made out against the petitioner for the alleged offense under section 363 and 365 of the CRP, IPC. Full stop. Full stop. Only because of the reasonable application pending before this court, the trial of the case is pending before the London magistrate. In view of the above, this court did not find any merit in the present application. Accordingly, CRR 164 of 2023 is dismissed. Full stop. The London magistrate is directed to expedite the trial. The department is directed to communicate this order to the trial court for compliance. Next.
18,
Lord, 18 I appear on behalf of the petitioner. Not seeking quashing of an FIR.
Yes.
Lord, under sections 303, that is theft, 317(2 is Lord, receiving of stolen property, that is 417 of the IPC, and 61.
Section 303.
No, 303 subsection 2 is theft, my lord.
Theft.
And
And
317(2 is my lord 411 receiving of
Receiving
stolen
stolen
property.
property.
And 61(2 is my lord criminal conspiracy. Well, this is that
How many
case.
petitioners?
My lord, petitioner, there's one petitioner.
How
with
many
your
accused
lordship.
in the main
My lord,
court?
the three accused persons.
Three accused. You are the main accused.
No, my
You
lord.
are
My
you are
lord,
receiver.
no, my lord.
Mm.
My lord, kindly allows me to, my lord. My lord, this petitioner, if my lord recollects, my lord, this petitioner is the wife, where my lord, the husband has alleged theft, my lord, from a shared household. And I was arguing this case yesterday. My lord, kindly takes up the FIR. My lord, the dates are very important. My lord, the
Who is
written,
the complainant?
my lord, the complainant is the husband.
And accused is the wife.
Accused is the wife.
I appear for the defect complainant, my lord.
My lord, the allegation is of theft from a shared household. My lord, the FIR is at page 11.
11 or 12?
11. My lord, 11 is the
Okay.
pro forma.
Yes.
My lord, the kindly takes note of the date of the FIR, that is 9/11/2025. The FIR came
9/11,
2025. The
Correct.
FIR comes to be registered.
Correct.
Now, my lord, page 12 is the written complaint. Not the operative part is first, second, third, fourth, fifth para, my lord. Fifth para, he says, where he tries to make out a case of theft. My lord, he says that when I was in Pune in the month of November and December 2024, my lord, he dates back, my lord, kindly take a note of this. He dates back to an incident of the year 2024, that too of November, prior to a year. My lord, when I was in Pune in the month of November and December 2024, my wife Srimati Moushwarkar suddenly came alone at Shiliguri on 28/11/2024 and returned on 29/11/2024 and stayed in my house without informing me. During stay at my house, she had stolen cash of rupees 30,000, one gold ring and one gold chain. Well, from this is how, my lord, he tries to create this. My lord, he brings theft into action. Now, my lord, I say that this is. Now, my lord, I say this is more of a retaliatory measure taken up by the husband to settle scores with the wife. But why do I say so? But kindly takes up, my lord, page.
So this is the allegation.
This is the main allegation.
Gold and the 30,000
30,000.
on 28 and 29.
Yes, my lord. Now, my lord, I file an application in the year 2023 under the DV Act. My lord, the application starts from page 21 of my application, which was registered as Miss Case 104 of 2022.
Page 21.
Page 21, my lord, of my application.
Yes.
Now, these are proceedings filed under the DV Act.
The wife filed.
But the wife filed against the husband.
You filed.
I filed, my lord.
Your Yes.
the application under section 12, 18, 19, 20, 21 and 22, my lord, seeking relief.
This is a 2022.
This is on in the year 2022.
What is the prayer in that?
Now the prayer is for maintenance and residential, restraining the respondent OP from disposing the petitioner. My lord will find the prayers at page 28 of my application. 28, my lord will find the prayers.
Right to reside in the sharehold
Yes, my lord.
and monetary relief.
Yes, my
Okay,
lord.
whatever it is. Yes, then.
But subsequently, the trial court orders of paying 8,000 as an amount of interim maintenance. But the husband pays none. But we go and file a misexecution suit. But it starts from page 30 of my application.
This is execution.
Execution, my lord.
Correct.
Subsequently, my lord, nothing works out. My lord, kindly takes up page 35.
Now, where is the order? Where is the
My lord,
order?
page 35 onwards of the order.
No,
with
with regard to the main application,
Main application, page 35, my lord.
page 35.
Page 36 is the operative part. My lord, it starts from ordered.
No, these are 23. These are petition 23. That is execution.
No, my lord, 23 was the residential relief. It is the
Okay,
order,
okay, okay. Committing any offense domestic upon the receiver
that the petition under section 30.
and monetary relief of 8,000.
Yes, my lord.
So the restraint for committing any domestic violence upon the aggrieved person in future, respondent in the direct to stay away from the petition and our child, open direct to secure peaceful atmosphere. Shareholder, yes.
My lord, now, my lord, what happens? My lord, kindly takes up page 37.
Yes.
But finally, page in 2025, page number 37, I file a mat suit being 182 of 2025, pending before the ADJ fast track court at Siliguri. Page 37, my lord.
37 is the
My lord, this is the filer. This is a information slip
information.
which says, my lord, that I have preferred a mat suit, not being 182 of 2025. My
You
lord,
filed.
25.
You filed.
I filed, my lord.
Correct.
My lord, due to oversight, I could not annex the filing number. My lord,
Okay, whatever you file the
but the date
matrimonial
is
suit.
important. I filed this mat suit on 3/11/2025. Not kindly takes note of this.
311.
But the moment the husband gets knowledge of this, but as a retaliatory measure on 9/11/2025, he initiates this FIR against me.
So this is on 3rd November
3rd November
25.
25.
Correct.
On 9/11/25, he initiates this FIR against. He initiates this written complaint. Subsequently, an FIR comes to be registered.
Okay.
And my lord, he alleges an incident that dates back to a year back.
24.
24, my lord. But this is the primary allegations. Now, my lord, I will only stick to the section 3032. 3032 goes away, my lord, 317(2) as well as 61(2) goes away. My lord, why do I say so? My lord, 379, in order to constitute an offense of 379, one of the primary ingredient is, my lord, that dishonest intention. My lord, even assuming, not admitting.
Not dishonest intention. No, first we have to see whether any recovery was made from the petitioner.
But the petitioner was granted anticipatory bail.
Whether the recovery was made.
That's right, my
The
lord.
investigation complete.
But
Investigation
after
completed.
that-
Place
After that-
here for the state.
For the statement, I'm holding the CD.
Yes. Where is the Caesar?
Charge sheet has not been filed.
Does it not filed?
No,
Any
the
Caesar?
videographs, my lord, it was evident from the pen drive, from the CC camera, that her presence was there. He had been there.
No, that is
Yes,
correct. With
on
regard to
28th, my lord.
the case has been initiated 2025.
My lord.
Correct. On November 2025, we are on May 2025, 2026. 7 months is passed. So whether any recovery because the only allegation that 30,000 rupees and the gold chain and gold ring. So to establish the case under 379, the recovery is if you are not recovered, so how you can prove with regard to the theft?
My lord, thing is that, my lord, is the bank transaction was also not seized, my lord, was taken, my lord, and from the bank transaction, it reveals that annual transaction between this petitioner and the other two accused persons were there. That is
Other two
PK
accused
Vishwas.
persons, how many accused persons?
Three accused persons. sir.
Who are they? Other two accused
PK
persons?
Vishwas and Dhruv Tiwari.
Who are
PK
they?
Vishwas is supposed to be is my teacher and Dhruv Tiwari is my colleague, my lord. PK Vishwas was my teacher.
No,
Why there will be transactions?
Why not, my lord?
just a minute.
My lord, this is the during course of investigation, my lord, if my lord goes, then my lord will come for conclusion.
But one more thing is there, my lord. Our son.
I
is
will
studying
come
at
to
Pune.
you. Don't worry. I will hear you.
As your lordship pleases.
What about the other two accused persons?
No, they have not yet,
They have not been arrested.
they have not been arrested yet. But the role of these two accused persons have been but demonstrated in page 13 of the FIR.
This petitioner, she got a notice of the.
No, still the investigation is going on. The two accused persons are not there. How the washing is?
Not kindly sees the role of the other two accused persons.
Maybe. See, the investigation is to be completed. Now the FIR, they are having the transaction. The other two accused persons are not available. Correct. If they will come and what are the transaction has been made, if it is justified, the investigation file the report, then you will get the chance at this stage how the court under the 482 how the court can hold the trial. Yes, whether this amount is with the of you or this amount is of the other accused person or with them, whether this amount of the 30,000 is with regard to the theft amount.
Lord, may I just say one thing, Lord, subject to your lordship's correction. Lord, when there is a status of shared household, Lord, from a shared household, if I remove something or if I take something, Lord, can it be given the color of theft?
Correct. See, it is not the husband and wife is having the good relationship. Here the case is that both husband and wife is not having the good relationship. There was a domestic violence. The court has passed an order. There is an order. Court has also passed an order with regard to the residence and the monetary relief that has been granted. Then you file the matrimonial suit. So it is not that the cordial relationship. All of a sudden, wife went to the police station and made a complaint. It is your case that you are not residing with the husband.
My lord.
That's why you file the domestic violence. And the court has passed an order. Yes, give the
Subsequently, shared household has been given.
So it is not that the same house where you are residing. It is not your case. Correct. Now, as per the CCTV footage, on the alleged date, you were present in that house.
My lord, that is what I'm telling. My lord, he narrates in the FIR an incident that happened in the year 2024.
Maybe that is the
A year later.
I am not telling your door is totally shut. Here, after going to the CD, this court find that because other two accused persons not yet arrested. Now here is the three things are there. One is with regard to your presence and the CCTV footage which the husband has produced, police has seized under the pen drive. Your presence in the at the house is there.
My lord,
One is one aspect.
my lord.
Second, with regard to the transaction. So that transaction, unless and it will not been confirmed unless and until the other two accused persons come to the, will be arrested and justification will be then.
Then, my lord, may I make make an
Second,
innocuous prayer?
Yes.
But if your lordship is of the view that, my lord, this application is premature, but my lord, gives me the liberty to withdraw with
Yes,
with the liberty to file afresh.
Yes, no problem.
Grateful,
There's
my
no
lord.
problem.
No, that will
That's why
suffice.
I am telling
My
you.
lord, that will
because-
suffice.
Because at this stage, the investigation is
No,
going
that
to
will
accused persons are not arrested.
My lord, that will suffice.
Even if she has any Sridhan properties, my lord, then there is a process. He has to come for a search
Though
warrant
the
under.
petitioner has argued the matter at length, but subsequently the petitioner
By
pressed
the
for
Honorable Chief
withdrawal of
Secretary.
the present revision application with the liberty to file a first at the appropriate stage. In view of the submission made by the counsel for the petitioner, CRR 159 of 2026 is dismissed as withdrawn. Liberty to file a fresh as and when occasion arises.
Too grateful.
CDB return.
19,
Lord, in 19, my lord, a report was called for, my lord, from the IC. He has actually prayed for time, but there is another difficulty, my lord. What my learned friend has stated that in 2019, in one of the matters related to this case, I was for the petitioner or the plaintiff or
Private
the
party.
defendant, private parties, my lord.
My lord,
So in that case, for me also it's a problem. Just now I came to know. Because
my lord, this is a very serious case, my lord, wherein a very serious offense has been committed, my lord.
What?
My lord, an arbitral award passed by Honorable Justice Ashok Kumar Ganguly has been tampered in 5 different times.
But the state cannot
State
operate.
cannot,
presently,
my
So
lord.
I'm sending the next circuit.
My lord, in the meantime, preemptively, the report be called for from the
What?
police. My lord has already directed to call for a report, my lord. But
my lord,
yet,
that has been complained. He has prayed for time. He has already been there, my lord.
Yes. Yeah.
He has stated that I have conducted a local inquiry into the matter and submit the following report for your honor.
Report is there.
He has prayed for time. man. And the matter is also pending.
Okay,
One
on the
case.
next complete, not complete inquiry file on that.
Well,
And due to personal difficulty, the land of PP in charge is not in position to appear in this matter. In terms of the order passed by this court dated 12th of May 2026, the in charge Siliguri police station has filed the report, yes, and paid for more time to file the complete inquiry report. In view of the above, the case is adjourned. Let the matter appear before the next available circuit bench. In the meantime, the officer in charge Siliguri police station is directed to file report on the next date fix. Next.
20,
20 for the petition, my lord. In this matter also CD was called, my lord.
Yes.
Sweet of them.
Yes, what is the matter?
My lord. My lord, CD was called last week.
Yes, mister, you are appearing.
My lord, এটা সিডিটা এই দেখুন আর সিডি কোন এসছে এই যে my lord, rest of the revision matters I'm not holding the CD. Only one matter which is fixed at 2, specially fixed at 2 p.m. my lord. In that matter I'm holding the CD. These matters, my lord, I need a time, my lord, one day.
Which one? These three?
These 3 matters.
You're not having the CD?
No, my lord.
Then the PP in charge. Prays for time to produce a CD. According case adjourned, let the matter appear before the next circuit bench. Next.
21,
21.
22,
My lord, 22, my lord. My lord, 22 one day, my lord. Kindly keeps it tomorrow, my lord. My lord has already heard it at length.
Which
my lord,
one?
my lord, 22, my lord. Okay, please, sir. 22. Rahul Tamam. এটা কালকে half part argument হয়ে গেছে already. 22. My lord, kindly keep this tomorrow, my lord.
21, 20,
Well,
20,
22.
21 next circuit, 22 tomorrow.
Grateful, my lord.
22, let the matter appear tomorrow. The TP in charge is directed to produce the CT,
এই এটা সিরিটা নিয়ে নাও। একটু কেস নাম্বারটা দিন না।
directed to produce the CT.
আমি কাগজে লিখে দিই।
Next,
23,
Lordship, praying for short passover, Lordship.
what's our password? Extension of
Lordship.
time, extension of interim order.
Lordship, Dr. Odun Chaudhary will be appearing. He's in, Dr. Odun Chaudhary will be appearing in this matter. He's in VC before the Apex Court, Lordship. Lordship, short passover.
এক্সটেনশনে কি আছে? এক্সটেনশন করিয়ে না।
এই যদি করে দাও তো ঠিক আছে।
হিয়ারিং হবে?
না না।
তাহলে ঠিকই আছে।
For extension.
What is the grant? Grant 1 for grant
No,
11,
grad is not there, my lord. I think within
Okay.
time.
It's subsisting, Lordship.
subsisting,
Yes, Your Lordship. It will end on
30th April.
May, Lordship.
Which order?
Last order, Lordship, end of
Extended till
May.
30th. So every time you're taking time, why? Why you're not arguing the matter?
Lordship, we are ready to argue, Lordship. Senior will be appearing, Lordship. Short passover.
You are having the CD.
No, my lord.
What is the matter?
Extension matter, my lord, we don't call for
No,
the
what is
CD,
the
my
matter?
lord.
Why the extension, every time extension, nobody is coming for arguing the matter on merit, all CRR is pending here.
এই briefগুলো অনেক সুন্দর briefগুলো তো আছে, অরুণী রয়।
You file the CRR, getting the interim order and extension.
Lordship, last circuit also we were ready, but only extension.
What is the case? What is the section? SC/ST?
Lordship, not aware.
SC/ST quashing. Learned counsel for the petitioner submits that the interim order is still the end of May 2026. Accordingly, she prays for extension of interim order. In view of the above, the interim order is extended till
নাম দিয়ে দেন, নাম দিয়ে দেন।
13th till 14th of May 2026 or until further order, whichever is earlier, let the matter appear
23 to
14
32 লিখে দে।
14 June now. 14 June safety as well. 16 June 2026 or until further order, whichever is earlier, let the matter appear for the next circuit.
Grateful, Lordship.
32.
Next,
24,
24, 25, my lord.
25.
I am appearing for the
I am
de facto
appearing
complaint,
for
my lord, in
the
this matter.
petitioner. And on the last occasion, Lordship directed the state to bring the CD. My lord, because we had represented that we are ready for the final hearing of the matter.
yes.
What is the heading extension of interim order, my lord?
That's why I find here all actions are, that's why now
That's
very
the con-
first day, I deprecate this trend. You persons are
Let-
know that when the interim order is going to be expired, why you're not mentioning the matter before the court? You are filing can and
The last occasion, day before yesterday, your lordship has taken the matter, my lord.
correct.
Your lordship direct the state, we are ready, my lord. The learned senior is
We are ready,
appearing
my lord.
virtually, my lord. Your lordship.
What is the matter?
Your lordship
You're not,
takes up
you're not
item.
having-
My
There's
lord, the
some
matter
order.
pertains to
You have
section
appeared in the
59
last
of the
day.
My
BNS.
lord, my lord,
You're not taking note of it.
Not
My lord.
available.
My lord, my lord, may I submit appeal for de facto
my lord,
complaint?
my lord, I am for the
My lord,
petitioner.
The
But if your lordship
the
can
petitioner-
kindly takes up item number 25 first.
My lord, I am
My lord,
requesting that in the matter
May I?
24 and 25 are together, are on similar, parties are similar in the matter. And I'm requesting, my lord, that the matter may be heard because the problem is that they have been having the stay on this matter for last 1 year. They have obtained the orders of no coercive action at our back, and this matter has been lingering for long. The matter pertains to section 69, whereas the investigating officer has not inserted section 63 and 54, which we are saying that it should have been inserted
It's
because
my petition, my lord. I was
sorry, sir, you
expecting
were
that
not there, so I was.
I'll be getting a chance.
And also, we have filed the supplementary affidavit just day before yesterday, by
But
which
the
we
problem-
have
but the problem-
some serious grounds against.
What a CD আছে?
What can be done?
What a
That
case
only one state advocate is there is handicapped. no CD is there. How without the CD, how the court can go into?
My lord,
If
if I
you
may
say
request, my lord, if I may request, my lord, may kindly once go through the supplementary affidavit which we have filed day before yesterday. My lord, it will reveal the character of the accused.
Kindly don't
It's a very
allow
serious matter, my lord. It's a very serious matter. He's an Indian Army officer.
filing supplementary
He
affidavit.
is targeting
Which
he
has
is
moral
targeting
relevance with
the
this case,
mother
my lord.
of the deceased
They are
Arjit
trying
Kaur
to
rape
delay
victim.
the matter.
He
It's
is-
my
he
case,
is-
my lord.
He is
This
targeting the
case can be
constitutional
decided
authority.
based on the
He
case
is
they cost.
targeting this
But
judges
because
of
we
the
have
Honorable Supreme
challenged
Court
the
of
FIR.
India. The character of
We
this
have challenged
accused
the
has to be
FIR.
revealed, my lord. It's very essential now.
Unnecessarily, this man is trying to prolong the matter, my lord.
This accused who is
He is also
serving major
accusing
in
the
the Indian
the
Army.
lawyers of the my lord, representing the parties.
The person who is who is a major in Indian Army.
Right.
We have obtained some tweets of this person. We have filed it on supplementary affidavit. It reveals the kind of person which we are dealing with,
But I-
and he has been given the
But I am
protection from
opposing
coercive action for
this
last
prayer
1 year.
to accept on the supplementary affidavit. This has no sense with this case, my lord. Only to prolong
The
one after
petitioner
other
even went to
affidavits
the
are given
extent. The
being
petitioner
filed.
even went to the extent of filing a separate writ petition against me, against my client,
They have
seeking
used
to
their affidavit.
initiate FIR against my client before principal bench at my back. It's a very serious matter, my lord.
Two
My
cases are there, my lord. One is NGB police station case number 411 of 2025 and another is case number NGB police station case number 210 of 2025.
Correct.
So both the CDs are required.
That's why.
If they are going for a contested application, let it be listed as a contested application tomorrow.
Let them bring the CD tomorrow. Will be or
There was already a
after tomorrow.
direction.
Will be do.
There was already direction the day before
Kindly-
yesterday, and then there was also direction the
Fix
last.
the time on day after tomorrow. Kindly fix the time day after tomorrow.
No, my lord, in that case, I'll request tomorrow because Friday will be the last working day for the circuit bench. So I can, my lord, I'm humbly, I'm
No
requesting
matter,
that
kindly fix the time at 10:30.
No. 10:30.
It's a 19.
And my lord,
On
if I may
Friday,
submit one
10:30
more
fixes
thing,
the matter.
and my lord, if I may be allowed to submit one more thing,
One by one.
we have also brought on record the complaint which we have filed with the commissioner against investigating officer for having been influenced in the investigation.
Record and
তোর
all.
মামলা তো ডাকতেই হবে।
By an order dated 18th of May 2026,
24 সিটি কোনটা?
Learned Counsel appearing for the state raised for time to produce case diary and according case was adjourned till today.
কিচ্ছু
When
শোনা
the
যায় না,
today,
আমার
when the
তো
matter
যে
is
অবস্থা না
called
এখন
today,
আমার।
the learned advocate and learned PP in charge pressed for time to produce the case diary on the next date fix. This could find that without the case diary, the case cannot be taken up for hearing. Accordingly, the case is adjourned. Let the matter appear on the second day of the next circuit bench. The PP in charge is directed to produce the case diary on the date fix. Supplementary affidavit filed by the petitioner be kept with the record.
Man,
So
kindly
the
extend the
topic-
interim
Opposite
order.
party number 2, opposite party 2 number has also filed.
No,
kindly
interim
extend the
order will be
interim order.
accepted.
will be taken.
No.
Man, they are
Grateful, my lord,
extending
grateful.
interim order.
Grateful, my lord.
No
No, it
interim
was-
order
it
will
was
be
their failure,
extended.
man.
Grateful, my lord. Grateful, my lord.
They have failed to produce an interim order.
26.
This is the,
I was
this is
ready
the
with the matter.
style here. Getting the interim order and every time you are
I
taking the
didn't
time.
pray
Yes.
for interim order. I'm ready to do the matter.
26.
I'm ready to do the matter. Kindly extend until the next
Then
hearing.
next.
Grateful, my lord. Grateful.
Come on
The
the
next matter is my
You asked
matter.
the time.
But 20,
Yes.
kindly, my application is pending.
Yes, item number 26.
26.
Line for
Yes. Item number 26. Yes. What is the main matter? I am not interested with the extension. What is the main matter? Come with the main matter. I will not extend any interim order unless and until you are ready with the main matter. Yes, start. Start. If you're senior, you start. You are having a brief, you start. Otherwise, I will pass an order on merit. This type of the practice, I will. Till date I am here, I will not allow this type of the practice. Only for extension of the interim order, this court will not allow.
Short pass.
How many matters will be passed over? Pass over.
27.
Affidavit of service.
Yes.
My lord, the application is for extension of interim order, my lord. My lord, I'm ready with the matter.
Where is the main
I'm
matter?
ready.
With the
I'm
main matter.
My lord, so my lord, the allegations are under sections 417, my lord, sorry, my lord, 376, my lord. My lord, that's why, my lord, the de facto complainant on last occasion also, when I applied for extension, my lord, I was ready for hearing. My lord, none appeared for the de facto complainant, my lord.
Not necessarily state is there.
Yes, sir.
If required, we'll see the de facto
My
complaint
lord,
required or not.
My lord. The typed copy that I'm okay, yes.
Charge sheet filed.
My lord, charge sheet has been filed, my lord. I had prayed for discharge. My lord, my discharge was refused, my lord.
What is
Against
the
that order, my lord, I've
sole
come.
accused?
My lord, I'm the sole accused, my lord.
Yes, what
My
is
lord,
the-
both are doctors, my lord. The de facto complainant and the petitioner, my lord.
Ah.
My lord, allegedly there was a amorous relationship between the two. My lord, the relationship turned sour. My lord, this criminal proceeding is instituted on the basis of that, my lord. My lord, the FIR, my lord, is annexed to the application, my lord, but I have a typed copy of the same, my lord, for my lord's convenience, my lord. My lord, 10 months delay, my lord, almost 10 months of delay in lodging the complaint, my lord, firstly. My lord,
That cannot be a ground.
my lord, as per the complainant, my lord, she states that the first incident, my lord, where she was ravished, my lord, that took place in May 2023, my lord. My lord, thereafter again, she alleges that on 26th of June 2023, again the incident happened. My lord, thereafter also she chose to continue, as per her version, she chose to continue with this relationship with this person. My lord, then finally, my lord, in March 2024, my lord, the complaint is registered, my lord. Now, my lord, with respect to the FIR, my lord, the allegations which have been narrated by the complainant herself, my lord, I will contradict those, my lord, from her messages, my lord, WhatsApp messages which have annexed, my lord, they are inside the envelope, my lord. My lord, I can refer to the pages, my lord.
That is the charge sheet document.
My lord, it is a charge sheet document, my lord.
The WhatsApp messages.
Yes, my lord. My lord, that's since it is the victim's name is there, my lord. That's why it could not be disclosed, my
No,
lord.
that is the charge sheet document.
Yes, my lord. Yes, my lord.
Then,
my lord, the allegation is that, my lord, the petitioner, my lord, he started wooing this particular complainant, and finally on 16/4/2023, she gave in, and she apparently a relationship started between these two persons, my lord. My lord, it has been further alleged, my lord, that at the end of May 2023, when she was visiting Jalpaiguri, my lord, both the petitioner and them met, they cohabited on that particular night. And apparently she was, something was mixed in her cold drink, and subsequent to that, she was dizzy and she was taken advantage of. Now, when she wakes up in the next morning, my lord, she confronts the petitioner, but then, my lord, the story becomes a little in the gray area there again. My lord, I've given you the copy of the complaint, my lord. My lord, then she states that again, she was, the tickets were not booked and she was forced to stay over, my lord. My lord, I'll contradict this, my lord. My lord, in her own messages, my lord, she has omitted those images. My lord, the tickets were booked. She never even stayed with the petitioner, my lord. My lord, completely, my lord, a relationship, my lord, did not work out. There was no promise to marry. My lord, this is simply out of vengeance, my lord. My lord, I will.
yes, charge sheet is there. Yes, CD?
It is fine. Mr. Lohani is appearing for the complainant, my lord, the de facto complainant.
That is different thing, but the CD.
My lord, every
that is
time, my lord, I try to do a final, I am in difficulty, my lord. My lord, for 1 year, my lord, I am not being able to sit for Masters of Surgery examination because of the pendency
So
of this
why you
case.
persons are coming in the late hours? Why you are not mentioning the very first week?
My lord, we had mentioned, my lord, there was some difficulty which happened.
Nobody has mentioned.
My lord,
Only for extension of time.
My lord,
Nobody has mentioned the CR is ready for hearing.
my lord, no, my lord, my lord,
What you mentioned?
My lord, we were ready for hearing, my lord, that's
Ready for, when you mention?
On Friday, on 15th of May.
15th, he mentioned on 15th, my lord. The advocate. My lord, I am ready, my lord, I can, if the CD
But the
can be
CD is not there.
I understand, my lord.
Only one day.
My lord, on the last occasion, my lord, I'll candidly submit, my lord, I had pressed upon a final hearing, my lord, that it could not take place, my lord. My lord, that's why, my lord, it was returnable after 4 weeks under contested application. My lord, one thing, my lord, I'll apprise my lord of, my lord.
Yes.
My lord, there is a delay of 7 days, my lord, in filing the application, my lord.
What application?
My lord, the application.
What is the interim order you got?
My lord, that is at page.
What is the interim order you are enjoying?
My lord, the interim order, my lord, initially was granted. My lord, that is at page 6 of my CRAN 3, my lord. My lord, page 6 of CRAN 3, my lord.
How many CRAN children?
My lord, that was subsequently extended, my lord.
Page 6.
My lord, page 6 of CRAN 3.
That
my
is the
lord.
first order.
Yes, my lord.
Heard on marriage, therefore the matter is placed pending. The sense case is not pending on the fast track court. Syllabus is stayed till 28.
My lord, then page 9
The
is my
trial
lord.
is stayed. Why you persons are not filing an application under 227 before the session judge?
My lord, I had appeared for discharge, my lord. My lord, this is a session.
227 also.
I know, my lord.
Why you not
My
filing
lord.
the application before the trial court? Why you are bidding upon the high court? I am giving the liberty. Go and file the application.
My lord, kindly, my lord,
227.
extend it, my lord. I am ready for hearing, my lord. My lord, they are not appearing, my
Here
lord.
it is
My lord,
very
how can the
difficult to
petition
High
be
Court
blamed
to
for the
take
same,
up
my
all
lord?
the matter.
My lord, if
I
the
will
de
give-
facto complainant does not appear, my lord, the allegations are such that de facto complainant.
Then
that
have you
petition is
filed
mandatory.
whatever the reason? the
My lord,
trial
one
court-
last extension, my lord, last chance to de facto
Sorry.
complainant, my lord.
File at 227 before the trial court.
My lord, now this application is pending, my lord. My lord, they are not appearing, my lord. How can the petitioner be blamed for the same, my lord?
That's why you were, because you know the burden of the High Court, only 10
My lord,
days.
I bow
Out
down
of
to
the
that,
10
my lord.
days,
I
three-
bow
three
down to that, my
Saturday,
lord.
Sunday.
My lord, I bow down to that, my lord. But kindly understand the predicament of the petitioner, my lord. For 1 year, this doctor is suffering, unable to get a degree because of the pendency of this case. My lord, I want the hearing to be done. My lord, whatever the results may be, my lord. My lord, we had informed the de facto complainant over telephone also, my lord. My lord initially stated that I am ready, then there's no, I am not ready, my lord. Every time this happens, my lord.
Though the land counsel for the petition submitted, the petition is ready to argue the matter on merit. The petitioner also filed an application for extension of interim order. This court find that the state is not ready with the CD. And without the CD, without the case diary, it is not possible for this court to take up the matter. Accordingly, case is adjourned, let the matter appear before the next available circuit bench. The interim order is extended. Interim order is extended till 10th of June 2026, or until further order, whichever is early, let the matter appear before the next.
My lord, CRAN 2
CRAN is disposed of.
My lord, CRAN 2 is the section 5, my lord.
CRAN 1 and CRAN 2.
My lord, 2 and 3, my lord.
2 and 3 is disposed of.
Grateful, your lordships.
Next.
28.
20 lordship, I am for the petition.
Then I
Lordship.
will.
28 time for the political party number 2.
ऊपर एक ले लेना क्या filing the application for condoning the delay for filing the grant. The petition has filed an application for condoning the delay filing an application for extension of interim order. Delay is controlled. Delay is controlled. फिर उसके बाद नीचे आता है. Yes.
For the opposition to PF authority lordship. The extension filed by the.
Who is for the petitioner?
I am for the petition.
Yes.
The matter is lordship. Alipur, yes.
Direction.
The Alipurduar PS case number 494/25.
You are for the
And for the PF authority.
The matter of-
state.
For the state.
CD now.
If
The petition
lordship,
has-
one instance, we filed a grant application for extension of the interim order.
The petition has filed an application being CRAN 2 of 2026, praying for extension of interim order, which is going to be expired on end of the May 2026. In view of the submission made by the counsel for the petition, interim order is extended till 12th of June 2026, or until further order, whichever is earlier, CRAN is disposed of.
Direction is upon the petitioner to file. Evidently.
I also filed a third view.
Next.
No, that evidently.
I also filed a
29.
third view.
Lordship,
Yes.
I am for the petitioner, already we have concluded our argument and also de facto complainant and also concluded his argument. Now pending for production of CD by the state.
Yes, where is the CD? Hearing concluded here.
Kumargram.
Last date
Since-
you are present.
Since April, the Lord, in this case, for CD, there is direction but not produced. Six, 4,
498A.
these two petitioners are sister-in-law residing in separate mills.
Private respondent here.
Private respondent, today I am not,
To serve the notice.
everything.
Yes,
is
they have
complete.
argued.
They have argued.
18th already the hearing concluded. You have been directed to produce the said. You have taken the time.
But already we have intimated, Malad. Kumargram is far away. But one day accommodation, but tomorrow, Malad, is the last one.
And why you persons are not including all the charge sheet document which you have received?
No, we have already all the documents have included.
Yes.
Nothing is left.
Yes. So what remains?
Everything is there. Practically, if I may submit that the necessity of CD may not be
Yes.
required. As 161, all the 161 charge sheet and everything is enclosed with the petition.
Who are the petitioners?
Sister-in-law, they are residing in separate mess.
Sister-in-law
Sister-in-law,
and
two sister-in-law.
both are the sister-in-laws
Yes,
of the victim of the de facto complaint.
de facto complaint.
Yes. Yes.
Because I'm not holding the CD, Malad. The paper, all the documents are there with the charge sheet, Malad.
You can argue that if you give the brief.
I have already given the
Then
brief,
nothing.
still then.
Here, here, here. Principal accused.
No. কিছু নেই এদের against.
কার জন্য এসছেন?
কৃষ্ণা বর্মন আর
কল্যাণী ব্রহ্মণ।
husband.
Malad, the allegations in the FIR is that, Malad, both, first of all, both are named in the FIR. Second is, in the second page of the FIR, that is the running page of this main petition 13, 1, 2, 3, 4, 5, 6, 7. The 8th line says that after this complainant came to the in-laws house, these petitioners, 4 and 5, at their instigation, the other accused persons have tortured them physically and mentally.
One day.
And not only that, there is also an allegation that the baby has been allowed Amar Bacha Nosto Korar jonno chap deয়. So he was forced to abort the
But
baby.
given birth.
He has not given birth. I has given
There is
birth.
no abortion.
And another thing is that another allegation is there after taken after 8 lines that on 12th of January 2023, this all the accused persons, they came to the paternal house of the complainant, and in front of them they used slang languages, and they also slapped her,
Now come to the
and they
page.
have asked for 3 lakhs
Now
rupees.
come to the page 18 of the independent witness.
My lord,
Last in between 5 lines. 1, 2, 3, 4, 5, 6 lines.
এবং বলে যদি 3 লক্ষ টাকা সেই সন্তানের ধরনের পেজ নাম্বার 18 my lord.
18.
Yes.
Gauranga Shah.
গৌরাঙ্গ শাহ। Three nonod is written. 2 nonods, means their in-law, my lord, daughter.
When? Which date? Now come to.
January month.
Then come to the page
পুত্র
24.
সন্তান হয়।
Page 24.
এই খবরটা পাবো।
Father of the victim, page 24.
There was a demand for dowry of 3 lakhs, that is there, my lord. And though that was for the maintenance of the child and all. So those things are there. It's a general omnibus in nature, my lord, so.
Then. Yes, what can be done?
The allegations are there, they are named in the FIR as well as the 161 statement, my lord. They have some role to play because the entire allegations of instigation is on them. In the FIR also, when they
That's why I want
complain,
to CD.
when they complain
That's why I
on the
want to
first
see.
occasion, my lord, the CD, my lord, all the documents are here. When the complaint on the first occasion, he lost the complaint. It's categorically stated, my lord, that on the instigation of these 2 petitioners,
That
the
is re- that's
other
why- that's why-
petitioners, that means
That's why the CD is required. Though the matter is heard at length, and the counsel for the petitioner and the counsel for the private and opposite party number 2 has concluded their argument. But due to non-availability, the CD, the matter could not be finally taken up for hearing finally. Accordingly, case is adjourned. Let the matter appear before the next available circuit.
Lordship, interim order may kindly.
Huh?
Interim order.
What is the interim order?
Interim order till 31st is in force.
The interim order is extended till 17th of June 2026 or until further order whichever is held.
But I am for the petitioner, my lord. May it
Yes.
please your lordships. My lord, this is my affidavit of service. My lord, the case was initially under section 406, 420 and 506 of the erstwhile IPC, my lord. The corresponding sections of BNS are there. My lord, in nutshell, my lord, I'll place the
Now,
facts
who is today's fix or what?
for
interim
extension of
order.
interim order. But after,
Persons are not insisting for the final hearing.
my lord, for the first time, this is appearing after motion, my lord.
Where is the interim order?
My lord, last order, 22nd.
Till?
My lord, till 31st of May, 2026.
Yes, you are appearing.
My lord.
CD is there.
CD is not there.
The counsel for the petition submitted the interim order is still demand of May 2026 and request for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 19th of June 2026 or until further order. Let the matter appear before the next session.
But we have been informed, my lord, that in the meantime, charge sheet has been filed. So liberty to file supplementary affidavit.
Counsel for the petition submitted the petition counsel for the petition submitted during the pendency of the state of regional application. The investigation has been completed and charge sheet has been filed. He prays for leave to file supplementary affidavit disclosing the charge sheet. In view of the submission made by the counsel for the petitioner, leave is granted to the petitioner to file supplementary affidavit disclosing the charge sheet and the documents. And will serve the copy of the same to the respondents within 2 weeks from date. Please the matter before the next week. Next.
31, Lord, I am for the petitioner.
Again, extension.
Yes, my lord. This is the affidavit of service, my lord. Last order. Lord, appearing for the first time after motion, my lord.
Interim order granted.
Interim order granted.
The counsel for the prince submitted, the interim order is till the end of May 2026 and accordingly pays for extension of interim order. In view of the submission made by the counsel for the petitioner, interim order is extended till 19th of June 2026 or till further order whichever is the matter before the next circuit.
But affidavit of service may be taken on.
Service captain that required.
I'm great.
32.
Yes,
Yes. 32, my lord, I am for the petitioner.
same,
Same, my lord.
same for you. Next.
I'm grateful.
33.
33, my lord, I am.
My lord, I'm for the
My lord,
opposite
I am
party,
for
my
the
lord.
petitioner, my lord.
My lord, in this matter, the learned conducting advocate of the opposite party is out of station for the purpose of his
Let it remain
father-in-law.
in the order of station.
For the
no
purpose of his
problem.
father-in-law's treatment.
Where is the
my
order?
lord.
Where is the order? The order
My
number
lord.
30.
My lord, kindly fix it in next circuit, my lord.
Where is the order number 30?
My lord, then kindly fix it day after tomorrow, my lord. He will come, my lord.
My lord, it is an page order 30 is there in page number
Yes, got it.
89.
Last one.
My lord, this is a application under Article 227, my lord.
What you filed? Order 7 rule 11.
Order 711 has been filed and it was, my lord,
You are the
rejected.
defendant.
I was for the defense.
Yes.
Now, in this case, my lord, the thing is that the defendant, the petitioner is a different matter. The plaintiff, they have filed a title suit that is 61 of 2022, which was pending before the civil judge, senior division, Jalpaiguri. And the prayers was very specific. There was a prayer for a decree for specific performance of contract, which was reduced in agreement, my lord. Before my lord goes to the, my lord, I'll take, my lord, the supplementary agreement, supplementary affidavit, my lord, wherein I have filed the agreement, my lord. My case is
Have you
that,
served the supplementary?
yes, yes. I've served the other side also.
Yes.
I'll give reply to it. I'll note me enough, I'll give reply.
Who is your senior?
Mr. Rajat Das, my lord.
Huh?
Mr. Rajat Das.
Problem.
My lord, I want to discuss before, man. This is my first civil matter.
My lord, kindly fix it on day
I got
after
an
tomorrow, my
opportunity
lord.
to put this matter. Not first,
Kindly
but
fix it on day after tomorrow.
tomorrow. Fix it
After tomorrow
Therefore,
is
not
not
possible.
Come. Next circuit, go.
My lord,
My lord,
please, my
wait,
lord. It's
wait,
a
my
very
lord.
small
There's no
point, my
time.
lord. It's under the Specific Relief Act, section 14D of the Specific Relief Act. If any clause which, if the contract is determinable, my lord, it's useless to file a suit. But only filing a suit is a clever drafting of the lawyer, nothing else, my lord. Only the prayer which they have asked for, the dispute is very simple, my lord. I'll just give a brief of the case. There was an agreement between the parties. As per the agreement, the total entire land was near about 3 acres, 3.09 acres. The rate was fixed 22,500,000 rupees per bigha. So it was the total amount was not written. It was written 20. That means the land, the purchaser even didn't know, they had no knowledge about how much land was there. Only on the basis of the chain deeds, this agreement was prepared. And after the agreement was prepared, there was a joint survey of the land regarding the physical possession. It was found that 1 bigha of the land has already been occupied by a local people who has planted tea plantation there. And it was a mature tea plantation. So for a long time, they were in possession. Now, how they have been in possession then, and we had taken 50 lakhs. We had not taken the entire amount also. Because the entire amount, how much is the entire amount? If my lord goes to the agreement, it's a very simple case. It was not mentioned. So we have only taken 50 lakhs advance, which we have stated that as we can't give you the possession and there is a clause staying in the agreement that if we can't give you the possession, we'll return you back the money. They are not taking the money. They are insisting us by filing this case to take the remaining balance and get the land registered. How can, my lord, a order be passed?
So you are in the part performance.
Sorry, my lord?
Part performance.
Yes, my lord. I have taken the amount. I am ready to pay. If the court founds or if there is, from my side, there is any lacuna, readiness and willingness from my side is not there, then I will be paying the damages also, my lord. But thing is that, my lord, here, instead of all the letters, documents are there. Now, what they have done by paying 50 lakhs, they have obtained an order of injunction from the ex parte order of injunction from the trial court, my lord. And now they are enjoying it. This is a case of 2022. 2022, 4 years. On the basis of that injunction, nobody can enter that land, nobody can change the nature and character of that land. Now they have only paid 50 lakhs. Every day the price of the land is increasing. I am ready to pay back the 50,000 along with the damages I've mentioned several times. The thing is that, my lord, in the agreement, as it was drafted in their instigation, my lord, it was drafted, only one line was missing. At that time, my lord can come to a conclusion because no final rates are maintained. How much is the total land? So that means the land was not measured. And it was on as is where is basis. Whatever it is, there may be some encroachment. We are also not sure how much land was encroached. But thing is that what they have done, very clever drafting, the word I should use, my lord, because even Supreme Court has used this word, but clever drafting of the lawyer. They have come with a prayer which the court cannot allow. Suppose if we come to a conclusion of the court and the decree is passed, what decree will be passed, my lord? I cannot give the possession of that land which has been encroached by a local person who has already planted tea in that land. Only thing is that, and not only that, their agreement, it's in a 10 rupees stand that has not been registered. 2022 case, now till now it has not been impounded.
No, that
Even then, that point, my lord,
take
that
that
my lord,
in
but my lord, if my lord goes to specific relief act 14D, my lord.
That's correct, but where is this?
My lord, I'll take my lord to 14D of this.
No, that's correct, but where is the
My lord, I have,
They are not able to give the answer.
my lord,
They are not here.
they are not here, my lord. In that case, my lord, fix it tomorrow, my lord.
Tomorrow also.
My lord, I'll give a written note. Let them also give a written notes. My lord can take it back to court. My lord, principal bench. My lord can pass.
Principal bench, this court is not having.
No, no, my lord. My lord, vacation is there. My lord, it's a very interesting case, my lord. I have also, that's why, as those, these are the last day, 2 days of the week, I prepared a written notes yesterday, my lord. I knew that this question will come, my lord. Because as I have a good case, they will definitely come with a prayer for adjournment.
No, my lord, it's a emergency only, my lord.
What is the emergency?
His father-in-law is hospitalized at Calcutta, my lord.
My lord, I'll be referring to decisions, my lord. One is of Supreme Court, Balaram
Okay,
Singh
let it
versus
come.
Kelo
Tomorrow
Devi.
your senior will be available.
Day after tomorrow, my lord.
Day after
Day after
tomorrow, how the
tomorrow
matter
is
can
it?
be taken?
And he
Tomorrow,
fixes
the
on
Thursday, he
top
said.
of the list, my lord. Day
Huh?
after tomorrow, my lord. It will take time for him to come from the Calcutta.
My lord, in the
my lord.
meantime, I'll file the written notes. My lord can also go through written notes also, my lord. And the citation, 2 citations I'm relying, my lord. Both are of Supreme Court. One is Rajendra Bajoria versus Hemant Kumar Jain, and one is Balaram Singh. Very interesting case.
As per the prayer made by the council for the respondent, let the matter appear on 22nd.
Grateful.
Grateful,
But
ma'am.
I don't know whether it will take or not.
Grateful, ma'am.
Grateful.
Next.
34,
Please, your lordship, my lord, I am appearing on behalf of the petitioner.
yes.
My lord, I have concluded my argument. My learned senior friend will advance, and then hopefully, my lord, I'll get a chance to reply.
Civil.
Yes, my lord. It's a civil division application. Suit for declaration permanent injunction. Order 7 Rule 11 was filed by me. I am the defendants. My Order 7 Rule 11 was rejected on the ground that it's a tribal issue. Now I have come up before your lordship, filing this revisional application, challenging the order that was passed in the Order 7 Rule 11 application.
Lord, on the last occasion, your lordship, Lord, desired us to, Lord, file a supplementary.
Disclosing the deed, yes.
Yes, it's containing that.
My lord, I have received the copy of this.
Yes.
No, my lord, if I may just, my lord, take your lordship back to the plaint once before your lordship goes into the deeds.
Yes.
My lord, the case made out in the plaint was that the predecessors of the plaintiff were the owners of a substantial chunk of land. Out of the total quantum of land of which they had title and possession, a portion of it was subsequently transferred in favor of someone else. That individual has subsequently transferred it in favor of the defendants in the plaint. So the scenario becomes, from the original chunk of land which was recorded in the RS record of rights in the name of my predecessor, substantial amount retained by us, which has devolved upon us today on the plaintiffs, recorded in our record of rights, a portion of it transferred to third parties, including the defendants here. So those two chunks of land become contiguous chunks. The schedules which are there in the plaint, we claim our absolute right on this portion of land. The defendants are claiming their rights on the area which they have transferred onto themselves. Those deeds are before your lordship by way of a supplementary affidavit. This, my lord, is not under challenge, not in dispute. Case made out in the plaint was, in 2015, they had acquired right over a contiguous portion of land.
So that's why, see,
Yes.
on the last occasion, if you have given that, you are the plaintiff.
I am the plaintiff.
Correct.
Right.
So,
My lord, kindly takes the schedules.
no,
on-
that's why.
Yes.
First you come to the paragraph 2 of the plaint, page
Correct, my lord.
17.
Yes, my lord.
Page 17 is the total details of the landed property of the Dharmakanta Singh.
Correct.
Correct.
Yes.
Dharmakanta Singh. So Dharmakanta Singh was the died, leaving behind his daughter
Yes.
Joswal. Joswari Singh.
Joyaswari Singh.
Joswari Singh.
Joyaswari,
Correct.
yes.
So at that point of time, when the Dharmakanta Singh died,
Yes.
what was the situation? The land was
Entire land
land was transferred to
devolved
the
upon
daughter.
Joyaswari.
Daughter.
Daughter.
Correct.
The
Now-
daughter
Now
subsequently,
that's why. Now come
para
to the
four.
paragraph 4.
4. Joyaswari transfers it to Subal Chandra Pal and Kalpana Rani Pal.
Kalpana Rani Paul.
Yes.
That is the deed number 5294 of 74 and
74.
5295. There are two deeds.
Yes.
Correct.
Right.
There are two deeds. The transfer the land 1.33 acres out of
Yes.
1870.
Not the entire land.
That's why.
Portion of
out
it.
of 1870.
Yes.
So remaining about 6.6 was remaining.
Correct.
6.84 was remaining.
More or less.
Correct.
Yes.
Then you come to 5.
Yes.
Furthermore, the Subal Chandra Paul and Kalpana Rani Paul executed two deeds.
Right. 85.
85 and 44 and 43.
Yes.
In favor of Madhav Chandra.
Madhav Chandra Pal and Shanti Ranjan Pal.
Shanti Ranjan Pal. This deed is regarding which portion?
This deed is regarding which Lord Joyaswari has already transferred
That
the portion of it. Yes.
That one.
That one.
Because Jayashree has registered in the name of the Kalpana, Subal Chandra and Kalpana.
Correct.
And Kalpana has executed, Subal Chandra and Kalpana has executed the deed
Madhav
in
Chandra
Madhav.
Pal and Shanti Ranjan.
So that is that portion of the 11.33.
Yes. Correct. Now this Madhav
Now-
Chandra Pal is the vendor of the defendants.
Madhav Chandra Paul is the
Vendor of the defendants.
who is the defendant secretary.
Correct.
So
this
this deed,
yes.
that is the now Madhav Chandra Paul
2015.
and Shanti Ranjan Paul became the owner in terms of that deed.
Yes.
Correct. Now
But
thereafter
only Madhav Chandra Pal Miller transferred
Yes.
his share.
Now 6.
Yes.
The Madhav Chandra Paul executed 3 deeds of sale bearing 97, 9887, 8358 and 9889 to in favor of the defendant society.
Yes.
Correct.
The next line is Miller, very
Thereby
important.
sold a substantial area land to the defendant society under the different plots. However, neither the
Joyaswari Singho nor her legal heir,
that is the plaintiffs, ever sold any portion of the Madhav Chandra in respect of the plots.
Yes.
So your specific case is that Madhav Chandra executed 3 deeds.
Yes.
Correct.
Absolutely
In
right.
favor of the defendant
Correct.
society. Sold the substantial land.
Yes.
So this area, what is the total land?
Total land, Millard, kindly takes up the schedule. Except this, Millard, a substantial chunk of land was transferred.
Because substantial you mentioned.
Yes.
So substantial how much area? Because the
Millard,
Madhav
it
Chandra,
will-
Madhav Chandra and the Madhav Chandra and
Yes.
Subal
Total
Chandra.
Total code, na? Millard, schedule A 12 decibels, schedule B 57, schedule C 188, schedule D 122, schedule E 72.
Correct.
So more or less, it would be 5 acres approximately. So that was the land which we had retained, which was never sold to anyone else.
Which one?
This schedule land on which we have
Schedule A to Schedule D.
schedule A to schedule. It's
E.
not 4.51 acres exactly.
4.51
51 acres.
acres.
Yes.
Acres. It has been sold by
No, it has not been sold. It has, Joyeshwari has never sold this land.
So that's
This
why.
has devolved
so
upon the
that's why,
plaintiff.
that will
Yes,
be
my lord.
clear.
Yes,
So thereafter, Madhav Chandra Paul,
yes,
who has purchased from the Subal Chandra and Kalpana,
yes.
he has sold the land, substantial land. So where is the deed?
There, my lord, this 2015 deeds.
Ah,
This we have, my lord, filed by way of a supplementary.
What is the total area in that?
তো ওদের রিটার্ন স্টেটমেন্টে পাবি একবার ওটা এডিশনটা করতো
9887.
পড়াও যাবে না টাইপ কপিও নেই না
Total of property sold by this deed. Now kindly come to the page 55 your document.
Yes, my lord.
Page 55 your document.
My lord is looking in the supplementary affidavit.
Yes, they have given that. Kindly come to the page
1.57.
Page 55.
Yes,
So total is 1.57 acres.
Yes.
Correct.
Yes, my lord. Second, my lord would find, my lord.
Second deed is 69.
Yes.
And schedule is schedule is 81.
81.
8.91.
Yes.
Correct. So 8191 and 1.57 plus 8.91. So it will come 10.48.
113.
So it will come 10.48.
Yes. Another, my
Correct.
lord would find that 113. Page 113. The
113.
third deed.
Yes.
The third deed, there's three deeds.
And third is
114. 114. 5.26.
113.
114. 5.26. Yes.
So it will 15.74.
Yes, because Madhav Chandra Pal not only purchased land from me, he had already purchased or had subsequently purchased land from other vendors also.
No, then
That's why
then the survey number is to be tallied.
No, Millard.
Then the plot number is to be tallied.
No, Millard, I am only saying this. Para 6, we have stated that this Madhav Chandra Pal has transferred, had executed 3 deeds of sale bearing number so and so, so and so, so and so, to and in favor of the defendant society, thereby sold a substantial area of land to the defendant society under different plots. Now, 7 accept this, Millard. Even then, Joyeshwari had a substantial portion of land which she had not sold. That Millard can find from the documents itself. The declaration I have sought with regard to my title
That's
and
why-
protection
that's
of
why-
possession.
See, that's why to clear that confusion.
Yes.
On that confusion only taking into that benefit, he has filed this application. Now you have to satisfy that, yes, the total land has been sold, there was nothing. Or you are having this much of area.
Probably it is their case that in 2005 I had sold entirely all of
Correct,
my
that's
land.
why- That's why you have to show
Yes.
you are having this much of the land.
Yes.
Where is that?
Yes, Millard would,
Because if we go by your paragraph 6, so paragraph 6 is 15.74.
yes.
Correct. Now you are telling that the 15.74, the Madhav Chandra Paul has not only purchased the property from the Joyeshwari and Subal Chandra,
He had other lands
other
also.
landed property. So now you have to see from which.
Now, Millard, para 6, Millard, if Millard kindly turns over the page, Millard, we have also pleaded in which plots and to what extent he has not sold. However, neither Joyeshwari Singho nor her legal heirs, i.e. the plaintiffs, ever sold any portion of land to Madhav Chandra Pal in respect of the following plots.
Correct. So now you come to the first page 55, your supplement.
Yes, Miller.
Correct. Page 55, your supplementary. So first land is the plot number is 338. First plot
Yes.
number is 338.
Miller, this was never purchased from me. This was Madhav Chandra Pal's self-acquired property from someone else. Miller, kindly take page 50 before that, Miller. The chain. Page 50, Miller.
Yes.
So, shop origination बोलना. কোথায়? Miller, kindly take page 50. Miller would find the name Sri Suresh Kumar Gupta, second line.
Yes.
From Suresh Kumar Gupta's chain, Madhav Chandra Pal had acquired these properties, which he had subsequently sold to the defendants. This is a different chain altogether, Miller. The next recital, Milord would find Durga Pal.
Just a minute. So this defendant is the purchaser.
Correct.
Page 48.
Yes, Milord.
Correct.
Yes.
And the seller is Madhav Chandra Pal,
Durga Pal and
Durga
Joydev
Pal
Kumar.
and
Joydev Kumar.
Joydev. Joydev is not with regard to this property.
No. He's not connected with
Not
us.
connected with this
Since,
property.
Milord, since we have also sold some portion to Madhav Chandra Pal, therefore this confusion arises.
Correct. That
Now,
is the
Madhav Chandra Pal has acquired property from different sources, from Joyeshwari's source, from Suresh Gupta and other sources. Thereafter, he has transferred some portion.
That's why now
to the
from this
defendants.
date, from this 3 dates,
Yes,
if you are telling that the Madhav Chandra Pal already purchased because paragraph 5.
correct.
Correct.
So this plot numbers is not there in the plan.
Paragraph 5, this 4385 and 4485.
Yes, Milord.
Which survey number you have purchased?
Milord, paragraph 5 of the plan, Milord.
Yes.
Yes.
Paragraph 5.
Milord, these two deeds, Milord, probably it's not part of the record today.
Not
85
the-
deed to
there
the-
is, there is.
আছে?
It's there.
Page number বলো। এই ইয়েটা
আগে আছে।
supplementary টা আছে।
Yes, 85 it is there.
I'm sorry, Milord, I'll just.
85 it
yes.
is there.
Deed number 44, Milord, is at page 34.
Page 34.
34.
And
Probably,
that is
Milord,
plot
the
number
first
four
annexure,
question.
that is deed number 43 is annexure A.
না না এটাও তো একটা ডিড, এটা কোনটা 74 প্রথম ডিডটা আছে ডি হচ্ছে
44. Where is the schedule? No schedule. Huh? Page 34 is the deed. Page 34 is the deed. Where is the 41? Huh?
The Milord is looking at the deeds of 1985.
85.
Yes, Milord
Deed
would,
number 44.
yes.
Correct. Deed number 44. Now
44.
finally come to the schedule A.
Yes, Milord.
Schedule A. 392. Plot number 392, 389. Have you gone through this all deeds?
Yes, Milord.
Yes, Milord.
So what do you find?
Milord, what I find is, may I clarify it, Milord, before your lordship? Milord, kindly takes up the supplementary affidavit for once.
Yes.
Yes.
Milord, before he starts, Milord, I'll just.
Very well, Milord. Let
Milord,
my learned
I'll
senior
just
continue.
indicate, Milord,
I
just
will not interrupt.
one line. 41, these 1985 deeds, none of the plot numbers Milord would find in my schedule.
So that's what I'm telling.
Yes.
Kindly
Milord, kindly cursorily have a glance at it, Milord. It starts from 392, 389, 398, 382, 405, 378, 364. Now, Milord, kindly takes my schedule.
that is not there.
That is not there. So today,
Because
Milord,
what the schedule you have mentioned, that is at paragraph 2 also the same.
right,
That
right.
is the plot number.
Yes.
Correct.
This is my schedule is, Milord, only those plots from which we have never sold any land to Madhav Chandra Pal.
Correct.
Now, these defendants,
Now, just a
admittedly,
minute,
Milord,
just a
had.
minute. Now, these
Yes.
are 44.
Yes,
Now
Milord.
43. Where the 43 have been disclosed? 43 are not disclosed.
No, 43 to me.
40
364, 392.
Yes, 43 is also there, page 21.
Yes.
Now page 21, the schedule, where is the schedule?
31 million.
31.
Yes.
This is also not there.
Not there. Next page, Millard would also find a bunch.
29 is also there, my lord. 29, page 29 also has a schedule A.
It starts
My
from
lord was,
29.
yes, my lord.
In the event the discovery non-payment of sanction, schedule A of the land of the vendor. Schedule
Page 30 also, Millard would find some plot numbers are there, 342, 345, 346.
This is also not there.
This is also not there. 31 Millard has looked at, 32 Millard would also have a look at, 342, it starts from plot 342. 342, 365, 367, and so on and so forth.
Yes. Nothing. Then
Millard, another deed starts at page 34 that Millard has already
that
seen.
is
Already seen. So these are the two deeds.
So these are the two deeds.
Yes.
So now you come to the 9887. 9887. Paragraph 6 deed, no?
Yes, Millard.
9887
Yes,
of
yes,
2015 deed.
Yes. It starts at page 45, Millard.
Yes, now come to the schedule at page 455.
Yes.
Correct.
And
Yes,
this Millard starts, I place this with the caveat that when Madhav Chandra-Pal starts selling to the defendants, he had not only acquired lands from me, he had
Correct,
acquired from
that's
other
right,
sources
that's right.
also. Suresh Gupta I have shown. This is Suresh Gupta's chain, which is
Now that's right. So
Yes.
now because as per your paragraph 6,
Yes, Millard.
9887.
Yes.
9887 is 338.
338, 338, 339. That's all.
338, 339.
Yes, that's all.
Two are there.
Two are there.
38, 39.
Yes.
39 in the two parts.
Two parts.
Three parts.
Three parts. Three or maybe 4 parts.
1, 2, 3, 4 parts.
4 parts.
So now you come to the page 90.
90.
338. Plot 338 consists of 0.28.
Yes.
Correct. Page 90 of your plane.
Yes, Millard.
Plot number 338.
338 Millard would find there are two parts there, 0.28, 0.99.
Yeah.
That quantum of land, Millard, probably becomes irrelevant as on today because that was the original land which Jayashri has acquired from her father,
Correct.
of which it has been sold to Madhav Chandra-Pal, a portion of it.
Correct.
Now, therefore, today, Millard, at Order 7, Rule 11 stage, what we are only submitting is, the case is that Schedule A land, A, B, C, D, and E, plaintiff has retained their possession or has acquired their title through their predecessors. Defendants having a contiguous chunk of land, they have purchased from several sources, including deeds executed in the year 2015. Now, enjoying a contiguous portion of land in 2024, they start making encroachment or trying to create a cloud over my title, which is my cause of action. That Millard would find Millard at page 15 and 16.
Yes.
That on 24/6/2024, tried to encroach upon the suit land and pluck tea leaves.
Correct.
So, Millard, the question of limitation, how this will bar me at this stage of, at the initial stage of suit.
Okay.
Because had it been, Millard, assuming his best case, had it been a case that in 2015 the entire land was sold out, that would have been an entirely different scenario. But the entire genesis of the plaintiff is the land which has never been sold to Madhav Chandra-Pal. Not in 2015, neither earlier. I am claiming title in respect of that, where a cloud has been created by way of their acts of Millard or attempts of encroachment. And therefore, Millard, I am within time. There is no question of limitation today, probably, Millard, which will hit my suit.
Okay. That's all.
That's all.
May I will quickly reply. That all the clouds, all the doubts will be gone, my lord. My lord, with all due respect and greatest of respect to my learned senior friend, my lord. My lord, at the first instance, the argument would look like it's at the first blush, it would look like very impressive, but it is fallacious because my lord kindly takes up the two things, my lord, side by side, the supplementary affidavit and the schedule of the plaint, my lord. Kindly takes up. My lord, kindly comes to deed number. My lord, kindly takes up first the schedule A. Schedule A, my lord, all that piece and parcel of land measuring about 12 decimal under RS plot number 563 corresponding to LR plot number 757 recorded in Khatia number such and such, part of RS Khatia number 13/1, Mouja such and such, such and such, such and such. Now, my lord, this very 12 decimal is a part of sale deed number 8358. My lord, let us come to 8358 for once, which is at page 72 of the supplementary affidavit. Now, kindly comes to the schedule for once.
Here.
Page 81, my lord. My
Page
lord, got it, my lord?
72.
Sorry, my lord?
Yes, continue.
Yes, my lord. Now, kindly seize, my lord, 563
Page.
my lord, page 81. Page 81 of the supplementary affidavit.
Yes.
My lord, seize 563 LR plot number 757 0.36 acres. Sold total land is 0.36 acre. Sold land is 0.36 acre to vendor number 1. Vendor number 1 is Goya Ganga. So, my lord, this total plot of land has been sold. So, with regard to this 12 decimal, the whole thing is sold, upon which, my lord, out of this 36 decimal, they are claiming right over this 12 decimal,
No,
which is a
so-
part of. Yes, my lord.
So, another plot number that 563.
Yes, my lord.
Correct. 563.
Yes, my lord.
Corresponding LR of 557.
Yes, my lord.
757.
Yes, my lord.
Correct.
Yes, my lord.
And the total area is 36 acre.
0.36
Oh,
acre, 36
0.36
decimal.
acres.
Yes, my lord.
And the sold total. To the
Total.
vendor number 1.
Yes.
So, you are the vendor.
So, my lord, kindly tallies one thing. LR plot number 757 is having 0.36 acres of land, which is the total land. Out of which sold amount is 0.36 acre. I mean, it means the whole land is sold
Correct.
out. Now, my lord, kindly comes to the schedule. They are claiming 12 decimals of land.
Correct.
This 12 decimal has to be a part of this 36 decimals of land. So, the whole thing is gone. So, until and unless, my lord, he throws a challenge to my deeds.
Now come to the page, paragraph 2 of the plaint.
Yes, my lord.
Paragraph 2 of the plaint, where the total area is mentioned.
Yes, my lord.
Correct. What was the total area?
757, 0.36 acres.
Where is the 757?
Page 18, first line. My lord, it's the stamp of the notary is covering that, but that is
563.
757. 0.36 acres. It's from the plaint, it is evident, my lord. From the plain prima facie, it is evident that whole land is sold. And they ought to have challenged this sale deed. They must have challenged this sale deed. Now, my lord, coming to the next deed. Yeah. I would go a little bit slow.
Yes.
So, my lord, with regard to schedule A,
Yes.
the plot which was sold or the portion in a plot of land which was sold is the subject matter of the deed number.
So now the schedule A, the total land, so 12 decimal does not arise.
Yes,
As
my
per
lord.
your case.
Yes, my lord.
Okay, next.
So, basically, my lord, the 36 was the total land.
Totally, so he cannot claim the 12. If he want to claim the 12, then he has to challenge.
No, my lord, my
How
argument
this
is-
can become a subject matter of order 7 to leave in application?
Of
This is
course
a
it
matter
has
of
to,
trial.
because it is a
If I
part of the
cannot
plain-
prove my
it is
title
a-
over the schedule and the suit goes.
No, 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 no.
No, his case is that Once he has totally purchased.
Yes.
Because you are claiming that you are claiming the 12th decimal in survey number 5, plot number 560.
Yes.
As per schedule.
Right.
Which is a
Is
part
your
of
claim.
36 decimal.
So you are telling that this 12 decimal has to come in your hand.
Right.
Correct. Now he is telling that you are claiming that decimal, but the 757 is the total area of 0.36. And the deed covers the total area.
Right.
If the deed covers the total area, so unless and until you will not challenge the deed,
I'm so
how
grateful.
their suit is maintained.
I'm so grateful.
That is the case he is made out.
Right.
So
Now, Millard, kindly assume the other view.
Yes,
A deed has
I will
been.
come to, I will come to.
Millard, yes, yes.
I will come to.
Let
But-
him
If
finish.
Yes,
my
let
learned
him
senior
finish,
friend
let him
wants to
finish.
complete anything, my lord.
No,
he
no, no,
can-
I will.
Very good.
Yes, next.
I'm grateful. Now, my lord, kindly, then, my lord, this 12 decimal must be a part of this 36
Okay,
decimal.
then next come
Yes,
to the
ma'am.
B.
Next. B. Schedule B, my lord, is also a part of 8358, my lord, the same deed.
7,
My
yes.
lord, page 81.
Correct.
Kindly takes up page 81, my lord. This is for 57 decimals, RS plot number 353, LR plot number 758.
Total
This
one
is just beneath that, my lord, that schedule, 757.
Yes. Yes, got it, got it.
Yes, my lord. 1.71 acres out of 1.71 acres. Total land is 1.71 acres, 1.71 acres sold. This is a part of, 57 decimals is a part of this 1.71 acres. Because the total land is sold. So in this case also, he must have challenged this deed. Schedule B is complete, my lord.
No,
Now schedule-
now come to the, this paragraph 2.
Yes, my lord.
Because we have to go by the plane.
Yes, my lord. Absolutely, my lord. I
Correct.
bow down. I bow down.
Where is the 757? 758, no?
758. 758, my lord. Just beneath that, my lord, page 18. 1, 2, 3, 4, 5.
758,
758, my lord. 0.86.
0.86. 0.86. And as per this one, 1.71.
Not tallying.
Not there.
Not tallying. True. But with respect to schedule 1, the whole property is sold. So this sale deed must have been challenged. My lord, now kindly, my lord, one thing I would show your lordship now kindly comes to paragraph number 6. 6, my lord, paragraph number 6 finds the mention or the averment is there with respect to 8358 of 2015.
Which one? Which one?
Paragraph number 6 of the plain, my lord. Just the
Yes.
kindly turns over page number 19.
Yes.
Paragraph number 6, my lord. See, my lord. 8358 of 2015. This is the deed that they have mentioned it.
Correct.
Yes, my lord. So they ought to have challenged this. This is my case. Now, my
So
lord,
this is the
kindly.
8358.
Yes, my lord. 835.
8358.
If, my lord, with respect to schedule B, they cannot challenge it, it is understandable because the total land is not tallying. Correct. But with respect to schedule A, the whole land is sold.
Okay.
Then if they are claiming 12 decimal, then they ought to have challenged this deed. Now coming to, my lord, schedule C. Schedule C is, my lord, a bit scattered.
So what about the B? B is the same.
B is the same.
Okay.
B is, my lord,
The total sold
Yes, my lord.
171, but there is a difference. But if you go by 181 also, the total has been
total
sold.
has been sold.
Okay.
So
then-
A and B is covered by 8358.
correct.
My lord. Now, with respect to, my lord, now comes to schedule C. Schedule C contains, my lord, deeds are there, my lord. I have the deeds, but it is not in the record. That is, one is 98888, 9889, and 9887. Now, my lord, as I find, my lord, 9887 and 9889 are subject matter of the record, and I would restrict my submission to that only. 9887 and 988. Yes. My lord, 733, plot number 733, second line of schedule C, my lord.
Yes.
733, LR plot number 733 has been sold by deed number 9888, which is not mentioned in the plain, so I will not get into that. my lord.
9888
Yes, my lord, 9888.
or 15.
Yes, my lord, all 15. 734, my lord, is the subject matter of 9889. My lord will find 9889 in the supplementary affidavit, page 99. Madam, sorry, my lord, I am taking a lordship to different deeds and different pages.
Page?
Page 99
Yes,
of the supplementary affidavit.
yes. Got it. Yes, next.
Yes, my lord. Kindly comes to the schedule for once. My lord, the first one. 338736.
Page.
My lord,
Triple one.
page 114.
1 1. Yes.
114. That is, my lord, 9889.
Yes. Survey number, plot number 734.
Maybe I'm making a mistake, my lord. Just give me a moment, my lord. Yes, ma'am.
Yes, 734.
Yes, yes.
114, 734.
So
the fourth
confusing
column.
at times, my lord. Yes.
Fourth column.
734.
Yes. Fourth.
RS plot number 338. 734 is the LR plot number. Area is 0. Total land is 0.80 acres. Here, my lord, sold amount is 0.80 acres. My lord has got it, my lord. The fourth one.
Got it.
Fourth one, yes. That's 734. 734.
Correct.
Now, my lord, 735. 735 also just the
So
next one.
First you come to the page, para 2 of the.
Very well, my lord.
Para 2 of the plant, 735. 735, 0.28. Seven, 3, 4.
Seven three five is not mentioned here.
No, 734.
Yes, my lord.
734. Where is the 734?
734 and 735 both are not mentioned here.
735 is there.
754 is
735 is the page number 19, third column. LR plot.
yes, my lord.
LR plot.
735 is there.
Yes.
735 is there.
735 is area 0.62. Total sold.
Yes.
But here 2. Yes, next.
Here is my lord 28 decimal point. Now, my lord,
734 is not there.
734 is not there. 735 is there.
Yes.
735 also, my lord, it's coming from 988 and part is coming from 9889. Deed number 9889.
Correct.
9889.
735 is 0.62.
Yes, my lord.
0.62.
Yes, my lord.
Total area.
Yes.
But as per the paragraph 2, that is a 0.2.
0.2.
Yes. Next.
735.
Yes.
735, my lord, I have shown your lordship from 9889.
That is good. That
Yes,
I
my lord,
got.
that is gone.
Yes.
My lord, another deed is there, 9888, which is not the subject matter. Again, I would not press that, but rest of the land was sold by virtue of this 9888. Now, my lords, kindly.
Now, what about the 736?
736 is 9887.
9887.
9887. My lord, the schedule is at page 55. 9887, the schedule is at page 55 of the supplementary affidavit.
Page 55.
55. The first one, the first column.
Yes, 736.
736. 0.40 acre, 0.40 acre wholly sold. My lord, what is that?
Yes.
Yes. The first one.
Yes. Then
Now, my lord, kindly takes up the next schedule, that is schedule D. Schedule D, my lord, the plot numbers are 730, 731, 732. LR plot numbers. This is the subject matter of 9889. My lord, the schedule is at page 114 of the supplementary affidavit.
Yes.
Yes, my lord. Kindly seize the first three, 730, 31 and
What is
30.
the deed number?
My lord, 9889, 9889.
Yes.
9889 is the deed number.
Hmm.
And first three, my lord, 730, 31, 32. Tallies it will schedule D, my lord, 30, 31, 32.
730, 731, 732. Total land.
0.83 acres total land, 0.42 acres sold,
Yes.
0.28 acres total land, 0.20 acres sold, 2.53 acres total land, 2.53 acres wholly sold.
Correct.
So each and every is tallying, my lord. Now comes to schedule E.
Yes.
E, my lord, the first plot is not there in none of the deeds. 737 is not there. I did not find any of the deed in which 737 is mentioned. 738, my lord, is the subject matter of again 9887. 9887, my lord. The schedule is at page 55. Kindly takes up 9887 for a moment.
Yes.
Yes, my lord. But 739 is also there, 738 is also there. Page 55.
Yes, 738, 739.
738, 739. 0.69 acre, 0.69 acre wholly sold, 0.32 acre, 0.32 acre wholly sold. So the whole thing is sold, my lord. 738, 739, my lord, we complete the schedules. All the schedules are, my lord, completed. Now the question before your lordship is, if all these schedules are being challenged, my lord has seen all the plots of land. I have taken your lordship through all the plots of land. My lord, all the plots of land are involved in these.
What about the 737?
My lord, 737 is, I have not found that.
Then?
That is the only plot. That is the only plot. But still then, my lord, if all the, even if we deduct 737, all the plots which are there, my lord, if with regard to those plots, my lord, my learned senior friend claims a recovery of possession, or if he claims a title, until and unless these sale deeds are set aside, this cannot happen, my lord. This will give rise to a non-executable decree, and challenge to the sale deed is a must. And because why they did not challenge the sale deed? Because the sale deeds were executed and registered in 2015. And
I appreciate.
Yes, my lord.
So what is your submission for till 37?
My lord, the submission is only one thing, that if they have not taken the averment with respect to the knowledge of the sale deed, then the knowledge has to be presumed from the date of registration itself.
Okay. Yes.
Because 2025 judgment, my lord, I have cited, I did not need
Millard,
not.
this entire exercise that my learned brother has done, Millard,
He replied.
Millard, it comes with a caveat that at para 4 and 5, originally Joyashree Singho has never conveyed these plot numbers neither to Subal Chandra Pal, Kalpana Rani Pal by way of the two deeds in 1974. Millard has seen that neither of these plot numbers were there, nor Subal Chandra Pal and Kalpana Pal has never conveyed this to Madhav Chandra Pal and Shanti Ranjan Pal. Millard has examined those deeds also. So prior to someone passing on the title to him over these plot numbers, that someone, the vendor has to show, or we have to see from where the vendor has got that title. I can, Millard, sell the entire High Court to my learned junior by executing a sale deed, by mentioning the plot numbers. Will I have the title to do so?
No,
That is precisely the case made out in the play.
That is correct. I appreciate. That is correct. If your case is that Madhav Chandra has executed the deed which he do not have the title, but you had the knowledge with regard to the deed as per the paragraph, as per the contents made.
No.
Plain.
Millard,
So
from
you
my
have to-
plain, Millard, this inference that I had the knowledge, Millard, probably at this stage is, Millard, misconceived, I would say, Millard, with deepest respect, because I have no source from where the defendant is trying to, Millard, encroach or step in my scheduled property, which I have never sold to anyone.
Okay.
So even if that comes to my knowledge, whether I challenge that sale deed or not, Millard, it is within my discretion what I will do with it. It is not for the defendants to, my lord, today advise me and call for rejection of the plaint merely because I have not challenged those deeds.
Okay.
And my lord would recall, my lord, taking into account, my lord, the pronouncements of the Honorable Supreme Court decision delivered by the division bench presided by Justice Somensen, Umapado Jati, where his lordship was of the clear view when I am not a party to the suit, I don't have to seek cancellation of deed. Merely I have to prove that the deed is not binding upon me. That's all. I can amend that my plaint subsequently, saying that all
There is
these
no
deeds are
amendment.
not binding upon me.
There is
That's
no-
enough. I need not seek cancellation because cancellation entails similar court fees on the valuation of the deed.
Correct.
So that was, my lord, a settled position of law. I need not seek cancellation. I have to merely seek a declaration that these deeds are not binding upon me, which I can do at any stage of the suit now.
Okay.
My lord,
So, my lord, the crux of the plaint is whether title has been transferred in respect of A to E, whether defendant having acquired from vendors to whom I have not transferred, whether defendant has acquired title. This is, my lord, the crux which has to be adjudicated by the trial court. Today, my lord, this Order 7, Rule 11 application and the proceedings, my lord, according to me, is, my lord, absolutely, my lord, misplaced and, my lord, premature.
Okay.
The question of limitation does not come from any four corners of the suit.
Okay.
no, just one.
My lord, we have few judgments, my lord,
The answer to my lord.
paragraph. Let para 7, my lord.
Citation take to book.
Yes.
Para 7, my lord.
2026 to ICC.
Where application under Order 7, Rule 11 challenges the plaint petition on the face and calls for rejection where the plaint shows no cause of action, is barred by law, or the relief claimed is not maintainable. The consideration of such an application ordinarily proceeds on the basis of the plaint and the documents annexed therewith. The court at this stage is not conducting a trial, rather it is performing a prima facie limited inquiry to determine whether the plaintiff has disclosed the cause of action and whether the petition plaintiff is legally maintained.
Correct. Next.
My lord, just one more, my lord. Folder.
Citation.
Citation of 2025 SCC online SC.
2025.
SCC online SC. 2240.
Yes. Para 15, 20. 15, 20, 23. That 15, that line is very important. At this stage, the defense is not to be considered.
Defense was never considered. Yeah. Not even annex the written statement.
Yes. Any further? Any other judgment?
No, that's all.
Yes.
My lord, the answer to my learned senior friend's argument lies in the judgment that I have already cited on the last day, my lord, 2025, volume 5, SCC 198. That judgment, my lord, paragraph number 11 and 14 specifically states and says that if a registered deed is registered in the way in the Registration Act, and if it is required by law to be mandatorily registered, and that the plaint does not disclose the date of knowledge, then the date of knowledge has to be from the date of the registration itself. So, well, deeds are of 2015.
In between the parties.
He has filed a suit in the year 2024.
They are not
made out that case, they came to the knowledge of. They have admitted there was a deed. But
Yes, my lord.
their case, specific case is that the survey number consists of several area
Correct,
which was
ma'am.
remained
Correct.
not sold,
Correct.
remained not sold, which they have a title over the property.
Yes, yes.
But subsequently, in November 25, they came to, on whatever the
That
date,
is the case.
they came to know that you are encroaching upon the plot. That's why they filed that. Clear,
Yes.
declaring the title over that remaining portion.
But they have also disclosed the deed. That is also
That-
part of the. Yes,
That's
my lord.
why.
Yes,
so
my lord.
they are not asking with regard to any deed or not. They are not challenging any deed. They are only case. They have made out a simplicity case that
Of encroachment.
okay, the property belongs to so and so, so and so. Subsequently, 2-3 deeds have been cleared, but the deed, these 3 deeds, not the total plot has not been sold. This part, 5 plots, 5 portion has been left out.
Yes, yes, yes,
Which he is claiming the title over the property.
Correct.
But
That
some
is the-
portions are there which where the total
Now
plots are
you
full.
are telling that no, that portion is not there, that is including the deed. So
That is precisely
I
the
am showing
defense.
him from his
So that's
document.
why you are
That is
telling
Miller
that
precisely
not
the
my
that
defense.
as per that deed, the totally land has been transferred. So he cannot claim. If you
Correct.
want to claim that, he has to challenge that.
So he
deed.
has to
So he
challenge.
has not challenged that
And
deed, the
if-
suit is not.
Yes, my lord. So
That is
suit not
precisely his
maintainable.
defense.
Yes. Suit is not maintainable, and if he has not given taken an averment with respect to the knowledge of the sale deed, then knowledge has to be counted from the date of registration itself. That is all. That is all that is stated in 2025 volume 5 SCC. That's clear.
That will come if he is challenging. Still, he is not telling that.
Melody he ought to have challenged. That is what I said.
It's not challenging.
And section and Dahi Ben's judgment I have also given to your lordship, my lord.
What can be done?
I'm so grateful to my lord.
Okay, thank you. Hearing concluded. Itna matter.
Melody is making CAV.
That I am saying, that I will come. Let it be there. If I get the time, I will dictate herein now.
My lord, there is some difficulty today, my lord. I can't stay because
Not required.
Honorable CM, my lord, I would have stayed. I wanted to stay, but because of Honorable CM is coming, so I would leave for airport.
Hearing convert CAV.
I'm so grateful. So grateful.
There is a village naam Kathana. You know the name? Yes, legal.
Just for correction.
This is not the time to mention. लेके कल करेक्शन के लिए रखिए।
Number 8 and 11, my lord, order has been already passed. It's going to be kind enough, my lord, and report my submission. This is my case, my lord. But I earlier, my lord, mentioned this matter, my lord.
That's why you persons are mentioning the matter. Matter is listed. When the matter is called in the morning hours, you persons are not appearing. What the court will do?
Your lordship, my lord, kindly report my order, my submission.
Your lordship,
Okay, we'll see.
may I be permitted to mention the matter?
This is not the time, what?
The morning I was-
You persons are not decorum of the court, you don't know.
But the order has already passed.
So what can be done? Okay, we'll see. Let me see. Huh?
Sometime back, I got a phone call from a patient. There's medical emergency backing up.
Which one?
It's a hearing matter, my lord. I'm not injuring the not matter if it can be taken up.
Okay. Okay.
Item number 4.
Item number 4.
CD was called for, my lord, I'm holding the CD.
My lord, upon direction, my lord, the parties are present virtually.
Yes.
Lordship, I am representing the Department of Blood. I am actually appearing.
Who is the petitioner?
Petitioner is Shumon Bosak.
And when
Unmute.
victim is also present.
Yes, Nisha.
What is the age?
Age is my lord 26.
Where is the victim?
Nisha Mahato. Ache.
She is also in control.
Nisha video
The
on.
victim.
Where is the victim?
Nisha video on karo.
Oh, there.
Yes. What is your name?
Nisha Mahato, sir.
Yes. What is your submission? What do you want to say? Are you married?
Hello, sir?
তোমাদের বিয়ে হয়েছিল?
Yes, sir.
So you want to continue the matter? You want to proceed with the matter?
Yes, sir.
মামলাটা কি চালাতে চাও নাকি?
আচ্ছা
নিশা
হ্যাঁ
মামলাটা চালাতে চাও? লন্ডন অনারেবল কোর্ট জিজ্ঞেস করছেন।
No, sir.
You want to proceed with the matter against the petitioner?
No, sir.
You already married?
Yes, sir.
বিয়ে করেছে নাকি?
पूछो ना।
আবার ফার্দার ম্যারেজ হয়েছে ওটাই জিজ্ঞেস করছে।
Further marriage, no, sir.
Who is appearing for the complainant?
I am complainant মানে সপ্তক সরকার।
Yes, Mr. Sarkar,
Yes,
please ask your client whether she is ask your client whether she is married or not.
No, my lord. On 30th April, their divorce has been completed, my lord. The mutual divorce with the present petitioner, and still
Mutual divorce?
with the present petitioner, my lord. Petition number 1.
Mutual divorce done?
Yes.
Of?
Mutual divorce between this.
Between the petitioner number 1 and the respondent number 2. Mutual divorce has been done, my lord.
Mutual divorce has been done. Why? What is the case?
This case is 498A and with some forgery allegation is there, my lord, for the some business transaction between the
Well, the
husband and
case
wife.
is that on 6th of October 2025, a complaint was lodged. And the written complaint does that this Nisha Mahato, she has lodged the complaint, my lord, that since her marriage, she was subject to torture and physically and mentally. He further added that he and her husband used to jointly run a management business named as Messrs. Adventures Event Management, located in Surjanagar Street, Siliguri. And few days ago, said Suman Basak added a new partner named Shikha Basak in the said firm. and also added Shikha Bashak as a bank account partner of the said business by a forged complainant signatures and making a fake partnership deed without her consent. So without her consent, another partners was invited, my lord, and he was admitted in the partnership firm.
Yesterday something, when they will file the supplementary, the supplementary.
Supplement.
Somebody is appearing, she's telling that she will file the supplementary affidavit disclosing the document. Where is that?
No, my lord, I was appeared and there were two cran. One is for extension and another is for the compromise.
What is the section?
Section is.
Sections are 85, 316 by 2, 318 by 2, 4, 390 by 2, 336. All of BNS, my lord. Cheating.
406 and 420.
So, charge sheet filed?
No, my lord.
Charge sheet filed?
Huh? Charge sheet has not been filed. The IOS present, no? The IOS present, my lord, with the CD.
What is the stage of the case?
Stage key is just running around. Oh, there was a stay from the honorable court. Oh, is your order? Oh. Lord, there was a stay.
Yes, it is there, 17th March.
My lord.
Proceeding is remain stayed.
My lord.
Where is the investigation is stayed?
Oh, that is the confusion now. This order, after getting this order.
Proceeding is stayed.
Whether
Investigation is not.
proceeding includes court proceeding or proceeding includes investigation.
Investigation has not.
My lord, we know that. We know that judicial proceeding investigation doesn't come within the purview of judicial proceeding.
Correct.
But judicial inquiry is something else, judicial proceeding is something else. But here thing is that already now on the basis of this, my lord, order, this they have collected the order, they have also entrusted the CD. Now the investigation has been stopped. Charge sheet ready, as in? Charge sheet is more or less ready.
So I am sending the matter to the trial court.
That will be better, my lord.
Because I don't know whether the victim is, but she is not giving the proper answer.
My lord, remand to Silu.
You are not filed proper application. Where is the compromise application with both the parties with an affidavit?
Yes, my lord. There is cran 2, my lord.
Who has filed?
Both the parties. Two affidavits are there, my lord. Page number 8 and page number 9.
But this is not compoundable.
Yes, my lord. My lord, I am guided by a judgment of Honorable Supreme Court, my lord. They are allowed for compromise.
You persons are not able to guide your clients. When this court has directed the parties to appear before the court, you could have been guided the client what is to be stated before the court.
Yes, sir. Yes, my lord. I have.
But she is not giving any answer. What practice you persons are doing, I don't know.
My lord, I have specifically guided her, my lord. Might be she become nervous.
What nervous? His advocate is also not able to say anything. These are 354, but here is the cheating.
Yes, my lord.
The petitioner has filed the present revisional application being CRR 101 of 2026 under section 428 of the BNSS 2023, praying for quashing of the FIR in connection with Siliguri Police Station case number 669 of 2025, dated 6th of October 2025, under section 85/316 within bracket 2/318 within bracket 2/318 within bracket 4/319 within bracket 2/336 within bracket 2 within bracket 3/340 within bracket 2 61 within bracket 2 of the Bharatiya Nyaya Sanhita 2023, read with section 3/4 of the Dowry Prohibition Act 1970 and Dowry Prohibition Act. Full stop. The counsel for the petitioner submit that the petitioner and the respondent number 2 are the husband and wife. Due to some mutual and due to some misunderstanding between the parties, the respondent number 2 has made a complaint before the police authority, and police has investigated the matter. In the meantime, both the parties have filed their application before the district judge. Where is the mutual cause of mutual divorce you got?
Additional
district judge?
Siliguri, First Court Siliguri.
First Court Siliguri for grant of divorce by mutual consent. That was allowed.
Yes, sir.
Mutual consent and on
30th April.
On 30th April 2026, the London Additional District Judge has granted mutual divorce between the parties. In the meantime, both the parties have settled their dispute, and the respondent number 2 being this application was filed when? After that?
No, well, prior.
Then before the decree of divorce is passed on mutual consent, the parties have come to the settlement, and the respondent number 2 being the complainant in the criminal case has undertaken that she will not proceed with the case, and she has no objection for release or for discharge of the petition from the instant case. On the basis of the mutual understanding arrived between the parties, both the parties have filed a joint application in the present case being CRAN number 2. Being CRAN number 2 of 2026. CRAN number 2 of 2026, praying for passing appropriate order on the basis of the compromise arrived between the parties. The accused, the petitioner, as well as the de facto complainant are present through virtual mode. The de facto complainant has submitted that though she has made the complaint against the petitioner, now she is not intending to proceed with the said case, and she has already filed an application by way of an affidavit, says she will not proceed with the case, and she has no objection if the proceeding initiated by her is caused. Full stop. The learned counsel for the petitioner has relied upon the judgment in the case of Surat Singh versus State of Uttaranchal, reported in
2012 12 SCC 772.
Yes.
2012 12 SCC 772.
Where is that?
Before the name of the Honorable Court, just have in the middle portion.
Volume 12, SCC 772, and submits that in the similar circumstances, the Honorable Supreme Court has held that if the de facto complainant in the similar circumstances, the Honorable Supreme Court has held that if the victim has come for compromise, come for a mutual settlement, and is not intending to proceed with the matter, there is nothing to there will continue with the matter, and as such the court cannot get it in, and submitted if the parties have resolved their dispute in that case, nothing remains in the suit and in the criminal case, and the matter can be settled between the parties. Full stop. Learned counsel appearing for the learned APP in charge appearing for the state submits that investigation has been completed, but due to the order passed by this court, the charge sheet could not be filed. At the learned counsel for the respective parties and the petitioner as well as the de facto complainant in person through virtual mode, the de facto complainant has submitted that though she has made a complaint before the police authority against the petitioner, but now they have settled their dispute and they have resolved their dispute by mutual consent, and she is not intending to proceed with the matter. Full stop. Full stop. In view of the matter, this court find that full stop. The de facto complainant and the accused, the petitioner have also filed a joint application being CRAN 1 of 2 of 2026, wherein it is mentioned that since the matter has been settled between the parties amicably, moreover, the respondent number 2 is ready and willing to withdraw the compromise her entire complaint on the basis of which the police has initiated the case, she has no objection, she has no objection for setting aside and for passing of the proceeding. In view of the above, this court find that the parties have settled their dispute and have also filed a joint application stating the fact. Full stop. Considering full stop, this court find that nothing will prevail. This court find that no purpose should be served by keeping the case pending before the trial court. Accordingly, the proceeding initiated by the Jalpaiguri PS being FIR number 669 of 2025 dated 6th of October 2025 under section 18 so on so on is along with the proceeding pending before the London Court of ACGM Jalpaiguri is set aside and passed. CR so and disposed of CR so along with the CAN so disposed.
Grateful lordship.
Next.
I'm leaving my name on the chat box.
35.
एक पासवर्ड है ना दो 3 नंबर 5 नंबर
26.
5 नंबर क्या होगा
Item number 5.
My lord, item number 5, I am for the petitioner, my lord. My lord, my learned senior has directed me to not press this matter as warrant has been issued in the against the name of petitioner and he is willing to surrender before the learned trial court below.
Counsel for the petitioner submit that the trial court has already issued the warrant of arrest and the petitioner is not intending to proceed with the present application and press for withdrawal of the present application. In view of the submission made by the counsel for the petitioner, the CRM within bracket A 141 of 2026 is dismissed as withdrawn. Yes, next.
Deeply obliged.
40.
I don't know 26.
Lord, I am for the petitioner, my lord. May it please your lordship. Lord, today, my lord, it is fixed for extension of interim order. My lord, the interim order is about to expire, my lord. It is subsisting till last day of May 2026. But my lord, I am ready with the matter, my lord. If lordship is desirous of hearing.
Counsel for the petition submit that the interim order is till 30th May 2025 and according the praise for extension of interim order and in view of the submission made by the counsel for the petition, interim order is extended till 19th of June 2026 or until further order whichever is earlier. Let the matter be placed before the next hearing. Next.
I'm grateful.
Nine.
My lord.
Nine. Also true. Oh. Not today. 9, 10 not today. All the 41.
35.
35.
35, my lord, I'm for the petition, my lord. My lord, this is the case quashing proceedings pending before the
Petitioner filed written notes, 19/3/2026.
Yes. Yes.
Petitioner want to written notes. City is required.
26.
Who are you?
RPF.
Huh?
468.
RPF means?
railway, this is the railway RPF.
So what you want?
CD is required.
So why you are present there without CD?
Inform that because of CM coming for few is not coming.
So if the CM will come, the total court will be closed.
Tomorrow.
I will record your submission. The London Council appearing for the RPF submit that due to the visit of the CM, is it not possible to produce the CD? Let this matter be placed before the legal remembrance with regard to the act of the London advocate appearing for the RPF for taking appropriate action. This is the matter before the next election. You are the advocates.
I inform and Lordship petitioner also filed written note.
What bar you are maintaining?
Well, actually, he's just
As per the prayer made by the council for the respondent, let the matter appear before the next available circuit. Not to make this type of a submission.
Instruction is that
36.
My lord, this is my application, my lord. My lord, this is a criminal division application for quashing of an FIR, my lord. This is a third FIR of 498A. First FIR is page 11. That is, my lord, 498A, only 498A before the Bagdogra police station. Case number 469 of 23, dated 22/9/2023, page 11.
Who are you? Who are
My
you?
lord, I am the, my lord, husband and in-laws are the accused of the FIR which is sought for quashing and seeking for quashing.
Who is for the state?
State
Who is
is last
appearing for the
occasion
state?
appeared and ensured that the
It is there. No CD.
CD is not there.
then, my lord, interim order be
APP
extended.
in charge. Praise for producing the CD on the next date fix. Accordingly, cases adjourned. Let the matter appear before the next available circuit bench. Next available circuit bench. Where is the interim order? There is no interim order.
Yes, my lord, there is an interim order. My lord.
By which order?
The first day, my lord, it's an order was passed, interim order was passed.
It is order investigating shall not take any coercive action steps against the petitioner for a period of 8 weeks. That is on 10th of October. Thereafter, no actions.
My lord,
No actions. Yes, next. 37 and 38. Yes.
Lordship, with 12th day, Lordship was pleased to pass an order for extension of interim order till today, and I have already served the copy before the Nagara police station and laid back the response.
Yes. You're appearing? Miss,
I'm appearing for the opposite person.
you're away. CD is there.
Yes, my lord, CD is there.
CD is there.
Lordship, in that case, Lordship, I'll pay for time because Lordship, in first half, I have asked for the CD, whether CD is there or not, because Mr. Senior Advocate, Mr. Abhishek.
Okay, I am vacating this order. You continue. I am staying vacating the entry model.
Lordship, they have assured me that there is no CD, Lordship. In that case, Lordship, Mr. Roy was present in the court and
Maybe.
Lordship, please kindly say, fix it on tomorrow. Kindly
Sorry.
fix it tomorrow, Lordship.
By an order dated 12th,
He will appear.
by an order dated 12th May 2026, this court has accepted the interim order till today and directed the Inspector in charge Pradhan Nagar to produce the case diary. London APP in charge is present with the case diary, but the London Counsel for the petition pressed for time. Accordingly, case is adjourned. The interim order is time vacated. The London magistrate is directed to proceed with the matter.
Lordship, I have been misled, Lordship.
39.
39, your lordship, I am appealing for the appellant.
Before the next.
My lord, I am for the appellant plaintiff, lordship. It's a hearing of a second appeal, lordship. My lord, it will take time, lordship. Can it be possible to shift the matter for the next circuit, lordship? Because it will take time, my lord. Second appeal and not order of affirmance, lordship.
Who is for the respondent?
Lordship, I am for this.
Yes, ready?
I'm ready.
My lord,
Yes.
I am seeking for shifting the matter for the next circuit because, my lord, I am online, my lord. It will be difficult, my lord, to conduct the second appeal, lordship. Order of affirmance, my lord. It will take time, lordship.
As per the prayer made by the counsel for the appealant, the case is adjourned. Let the matter appear before the next available circuit bench.
I'm great, extremely great, my lord.
Next.
40.
40, not today. 40, not today. Next.
41. Felt का होता था जी कौन Oh. Lordship, there has been some the brief two matters are tagged together, but this thing is happening for a considerable period of time. Lordship, actually two matters cannot be tagged together as because one, the conviction was for 5 years, another for life. So when I was moving the
there are two appellants.
Two appellants, and so the conviction for life, the appeal has been preferred before the division bench.
Correct.
When I was moving there, the present record was also taking with the same.
Correct.
And now I have made an application.
So what has happened to that appeal?
It is pending. Paper book has not been
prepared.
Not been
Here the
prepared.
paper book is ready.
No, Lordship.
So
Now my point of this is that, Lordship, this is the affidavit service. Kindly says, Lordship, the bail was granted on the very first day here. The appeal was kindly says page 6.
Page 6
of this relaxation that is can application. Can go to it. Ishita kothay? Hote geche naki?
Ki korchi?
Chilo lekho.
Can 2.
Lordship.
What is the name of the appeal?
Lordship, Mohabbat Khan. Mohabbat Khan, Samsul Khan, Kavita Begum.
41, what is the 41?
41?
Serial number 41 क्या है?
41 पे देखो तो
29. हाँ? 29. Serial number 41.
Shahidul Khan.
Shahidul Khan.
Shahidul Khan is before division bench, Lordship.
इसका फाइन यहाँ क्यों है?
That is happening.
अन्य लोगों से हो नहीं सकता.
No, this relate to the same case, na?
Maybe, but one is a life
Relate to
sentence.
same case. One is life sentence.
Yes, one line of sentence. That will be before that court.
For the division bench.
We have preferred with the appeal before the division bench. Appeal has been admitted.
Because
but at that juncture also we have
High
found
court record is same, my lord. That is the reason. That's why the files
so you
are
have to make
together.
2 copies of the same.
The trial
Paper book
TCR
has
is
to be
written, my lord.
Now, what is the
TCR.
stage of this? Your CR8.
CR8, Lordship. It has been admitted.
By which order?
Lordship, Lordship finds
this is CRAN 1, admission order. Lordship, page 6 is the bail application.
Bond of rupees 20,000 with two securities.
Lordship.
The power director to other direction. Where is the bail appeal? This is a CRAN.
This is the CRAN.
Where is the appeal?
Appeal, Lordship, I have the.
Where is the admission of the appeal?
The order. Appeal होते पारे ना तो होते पारे ना
अरे बाबू वो दूसरा केस
Appeal of CRA 8.
CRA 8.
CRA single bench 8, 2025, Muhammad Khan.
Strongly called. Appellant is the father. By which order the appeal is admitted?
Lordship, I don't have that appeal order here, but the record CRA 8.
Yes, appeal is admitted.
Lordship.
Consider ground assigned by the appellant, the appeal is admitted, divine director to issue notice, TCR be called for. Already preferred an application CRAN. So
now the CRAN application.
June 25, the appeal is admitted.
Lordship.
Paper book is to be prepared within 6 weeks.
Lordship.
So what has happened?
It has not been prepared. Now I have filed this CRAN application.
CRAN number?
CRAN 2. Kindly sees the order of CRAN 1 in page 6 of my this CRAN application. Bail was granted.
Correct.
With a condition, terms of the page 7, second paragraph. The appellant would once in a month appear before the trial court, being the learned additional district and session judge, first track, second court, Alipurduar. This was the condition.
Two surety, one will be local. The appellant should once in a month appear before the learned trial court, being the learned additional session judge. The officer learner would be maintained. The officer learner trial court would maintain the record regarding the regular appearance.
Lordship, now comes to page 8 to 11. Page 8 to page 11. The orders that I am appearing as per the direction of Honorable High Court. And page 12, the report of the court. Lordship finds in the order that within every 6 months the report has to be filed.
Correct.
The report is in page 12.
Correct.
And page 13 to 20.
Appearing before this court once in a month since
Lordship.
Now,
Now page 13 to 24, copy of that that khata which has been the excess copy where my attendance is marked by the bench clerk. And page 25 to 27 is the release certificate. When I was released from the jail.
No problem.
Now my application before this court is that that condition, the bail condition in page 7, that to meet once a month.
Correct. To appear before the trial court.
Now, as because the appeal is pending here, if that can be little modified, as because Lordship, this person is the Muhammad Khan, is a very aged person, and Samsul Khan, Lordship, he happens to be a Delhi laborer. He was working in Andhra Pradesh, but due to this, every month he could not go there. A matter of bread and butter, Lordship. Condition only for 5 years.
Correct.
So that if that can be relaxed, this is my application, Lordship.
No. Expedite the trial. Prepare the paper.
Trial has already.
No, expedite the hearing. Paper book is to be.
Now, paper book is not.
What is the? You are appearing in the division bench also.
Yes, Lordship.
So what is the direction there?
Same.
Paper book
Paper book
direction. Is there. When the direction was passed?
In division bench, Lordship,
division bench.
that file I am not carrying because it is not to the division bench.
He's not got bail.
No.
Life.
No. Like this. So at least once in a 3 months, Lordship.
No.
Because I'll not have gone. Because Lordship, if I can show Lordship, if TCR is here, Lordship, I'll put record. The dying declaration which was recorded, the entire allegation is against the husband. No whisper even regarding these persons.
TCR এর জন্য এটা হচ্ছে সাহি দিলে
So order কত দেয় বলো Lordship 12/6/2025 order.
Yes. Yeah, 10/6/2025 and there is 12/6/2025. Two orders have been.
12
The
6
division
2025
bench
lordship.
has passed an order for requisite number of paper book. Appellant to other sons so admitted. Sufficient number of paper book. Arrival of TCR. TCR already came.
Cosby shows that TCR has arrived.
Yes, nothing there.
Lordship. Lordship, at least once in a 3 month lordship.
No.
Little relaxation, lordship. Something.
The petitioner has filed the present application being grant 2 of 2026, praying for relaxation of the modification of the order passed by this court, by the coordinated bench of this court in CRAN 1 of 2025, dated 13/6/2025, wherein the appellant is directed to appear before the learned trial court, being the learned additional district and sessions judge, fast track, second court, Alipurdwar. Learned counsel for the petitioner submit that the petitioner is complying with the order by appearing before the learned trial court once in every month, and he has disclosed the certificate, he disclosed the document to show that the petitioner has complied with the conditions imposed by this court at the time of grant of bail. Counsel for the petitioner submit that the petitioner is aged about 60 years and had to go to Hyderabad for his what is the circumstance? You mention nothing. You not mention anything. Where do you mention? Why you wanted to relax?
Para 4.
Yes. क्या बोला? The petition is old age person, old age person, and is continuous and under medical treatment, and is also medical treatment, and he prays for relaxation of the oblique modification of the condition imposed by this court. Consider the application filed by this court. Consider the application filed by the petitioner. This court find that the petitioner has been convicted by the learned trial court for the offense under section. Where is the conviction?
304. This is 304.
For the offense under section 304/34 of the IPC, and convicted and sentenced to suffer RI for 5 years. 5 years. And also sentenced to pay rupees 10,000 in default. He shall further go imprisonment for 6 months. 6 months, full stop. 6 months, full stop. This court find that the trial court has already held guilty. Already passed an order for trial court has already held guilty against the petitioner, but this court has granted bail, and as such, this court did not find any justification to relax the condition imposed by this court while granting bail. Accordingly, CRAN number 1 or 2 of 2026 is dismissed. Full stop. This court find that by an order dated. This could find that by an order dated 10th of June 2025, directed the department to prepare the requisite number of paper book on receipt of the trial court record. This could find full stop. The trial court record has already been received by the department. Accordingly, the department is directed immediately to prepare the requisite number of paper book within a period of 4 weeks, 4 weeks, list the matter after the period of 4 weeks. Next.
43.
Yes. उसका ऑर्डर नहीं कर, खाली हमारा पार्ट है वो डिवीजन बेंच वाला में ऑर्डर नहीं कर, मैं तो मुश्किल हो जाएगा. Item number
43.
who is appearing for the petitioner?
Right.
Huh?
This probably from, I think, coming home. Right? Hey, look, right? Right?
When the judgment was passed? June 25. Conviction under 007, 7 years.
Yeah, five, can one and can two is pending.
None appears on behalf of the petitioner. So and so, learned APP in charge is present. Let the matter appear before the next circuit bench. Next.
44.
Pay the entire audit amount.
Place for time to filed. Yes. You are challenging the impugn order. Award. Along with the statutory amount, 25,000. Earlier you filed, where is? Yes, 25, deposit trust. Yes. Paper book. Not served. File the paper book. You are the insurance company. Land council appearing for the appellant. Submit has shown the challan number 28 dated 18th May 2026, wherein the petition, wherein the appellant has appellant / insurance company has deposited the awarded amount of rupees 17,07,436. 436. Give the copy of this challan. Copy of the challan. Yeah. Copy of the challan be kept with the record. Full stop. The office is directed to submit the report with regard to the deposited amount by the insurance company. As the insurance company has deposited the statutory amount of rupees 25,000 as well as the awarded amount. Full stop. The award passed by the learned tribunal in MSCC case number MSCC case number 18 of 2019 dated 19th January 2025 is state full stop. The appellant is directed to file requisite number of paper book after serving the copy to the opposite parties to the respondents. List the matter after the period of 4 weeks. Next.
45.
उसमें क्या पेन है?
My lord, I beg to appear on behalf of the petitioner, my lord. My lord, the matter is
Just a
ready.
minute, just a minute. Grand 1 of 2026 disposed of, huh? Grand 1 is disposed of. Yes.
My lord, I beg to appear on behalf of the petitioner, my lord. My lord, we are ready for hearing, but since the other side advocate is not present today, I am praying for the next circuit. But my lord, we have already prepared the paper book. If my lordship permits, then I would like to
Who
submit
are
the
you? You are
paper
the
book.
claimant.
My lord,
Claimant has filed the appeal.
my lord,
What ground?
my lord, it's for the enhancement of the compensation, my lord.
On what ground?
My lord, the grounds are. My lord, basically the notional income considered by the learned tribunal was very less. It was only
5,000.
5,000 rupees per month. And also, my lord, there should have been a.
What the deceased was doing?
My lord, the deceased was a private tutor. He was
Private
only
tutor.
17-year-old, my lord.
Private tutor.
My lord,
So what is the document you have produced that is guy 17 years?
17 years only. He was a
17 now,
student and
how-
also.
how he is taking the tuition?
My lord, how he was doing private tutoring,
How?
my lord.
He's the minor.
But my lord, nowadays the school boys are also doing tuitioning.
Yes, next.
And also, my lord, the filial consortium was not considered while calculating the general damage, my
served?
lord. My lord,
It
I'd
is
like.
admitted, appeal is admitted.
Yes, my lord.
By which order?
Let me.
Right to serve notice, yes.
My lord, the order dated 24
Yes, yes.
9 2024.
TCR. TCR has come.
I'll go to.
TCR has come.
My lord, I would like to submit the paper book. My lord, we have already prepared the paper book.
Find it. Ready?
But
Paper
my
book's
lord,
ready.
since the other side advocate is not there, my lord,
File
kindly.
it and so file it. The learned advocate for the appellant has filed the paper book. Let the same be kept with the record. The learned advocate for the appellant is directed to serve the paper book to the respondents and to file the affidavit of service before the next available circuit bench. This is the matter before the next circuit bench. Next.
46.
My lord, for item number 46, I am appearing on behalf of the petitioner. My lord, the paper book is ready. I would like to submit the paper book to the court and also to the learned advocate of the insurance company, my lord.
And counsel for the appellant has filed the paper book. Where is the paper book? Filed.
No, my lord, I would like to submit the paper book if my lord
File the
permits.
paper book. Let the same be kept with the record. The counsel for the appellant is direct to south and to third. So ready? As the director serve the copy of the paper book to the learned counsel for the respondent, list the matter before the next available circuit bench. Next.
Grateful, my lord.
47.
Ati?
47. I'm for
47.
the appellant, lordship.
Yes.
The respondent
Ready?
also appearing, lordship.
Yes.
Yes, lordship.
Ready?
Paper book has not been filed, lordship, but I
You are
have
for
filed
the
this.
insurance?
Appellant, yes, lordship. National
Insurance
insurance.
company?
Yes, lordship.
Yes. Who is for the opposite? Yes. Ready?
Lordship, may I proceed?
Yes.
Yes, lordship.
You proceed. You proceed.
Lordship.
What is the ground for challenging?
Lordship, the kindly sees the stay application, page number 8, lordship. Page number 7. My grounds of appeal is there, lordship. Paragraph number 8.
Appeal.
Stay application, lordship.
Stay application.
Page number 7, lordship. Stay application, the can 1.
Page number 7. Para 7.
Para 8, lordship.
Right. 62 lakhs.
62 lakhs has been granted, lordship, but our case is that the disease was a businessman, lordship. After his death, lordship, the family is running that business, lordship.
So Lordship, I am relying upon the judgment of the apex court where the income is not dependent upon the deceased person. The other family members is continuing with the business and they are earning, Lordship. Then the appropriate compensation should be allowed by the court below, Lordship, but that has not been followed, Lordship.
Where is the award?
Page number, Lordship, start from
88.
88, Lordship.
88.
Yes.
Where is the award? Last. Where is the calculation?
Lordship, 119, 119, 119, page number 119.
119. Loss of dependency. Where is the calculation? Kundal, estate, loss of consortium, 10% increase of the conventional rate, 62 lakhs. Where is the calculation? Where is the monthly income it has been taken? How the monthly income is taken into consideration?
Lordship, page 94, Lordship.
Page 94.
Yes, income of the deceased. 6,42,963 per
94.
annum. 94 rupees.
Income of the deceased?
6,42,000.
Per annum.
Yes, per annum.
As per the assessment year 1819.
Yes, Lordship.
Annual income deceased 6,40,000 per annum. Fix the annual income 6,42,000. Yes, so.
Yes, Lordship. So during the death of this claimant's family, Lordship, he is a subsisting business and that business continues after the death, Lordship. The court should not grant it as a whole, Lordship. I am relying upon the judgment of the apex court, Lordship. First, may I hand over?
Here, Ramya. Yes.
Even we are relying on this.
Yes.
Yes, Lordship.
Which paragraph?
Paragraph number 22, Lordship.
Document produced and record indicated date.
Here this is income is
That is with regard to the partnership, building commercial
Lordship.
complex.
This is having the multiple business, Lordship. Then court considered that for managing that business, Lordship, he should
No,
consider.
here the deceased who died in the accident was the income tax payee,
Yes,
and
Lordship.
he has, as per the last income tax paid by him, 1819. What is the date of the incident? 1819. 1819, 6,42,000 was the income he has
From
shown.
the other sources, many businesses. He is having many
Yeah,
businesses.
so might be.
Yes, Lordship.
So court has to see the income, whether what is the source. Other might be 10 business. If suppose the multimillionaire had died
Yes, Lordship.
in the road accident, he is having the so many multinational companies having. So you can say no, multinational company only you take the one company as a income of the deceased.
No, Lordship, but in this case, Lordship, the court has considered that the business is now transferred to the legal heirs, Lordship. those who are claiming the compensation, Lordship.
Correct.
And the court considered that if someone who is managing the business got 25,000, court has considered that 25,000, and then increase the amount considering the management skill, Lordship. In this case, in this present case, Lordship, the deceased is a businessman. Now business is transferred to the other legal heirs, Lordship. So for the managing this business, court should consider that amount that is fixed for any salary, like if
suppose a government servant died.
Yes, Lordship. Then the only
Just a minute.
Yes,
A
Lordship.
government servant died.
Yes, Lordship.
The legal heirs will get the monthly pension and all the deposit which is, and he uncompensated appointment he got. So we'll say that amount will be deducted.
No, but in
Then-
business, no, Lordship, but in the business, Lordship, there is a high chance to increase the income. But in the service area, Lordship, the pension should always
High
be
chance to
less.
increase the income.
Yes, Lordship.
Okay, might be.
Yes, Lordship.
The same thing, if he given the compensation appointment, subsequently he got the higher post, he will resign the compensation appointment and he will go to the higher post.
But Lordship, this similar fact, Lordship,
Show me which is the fact. Show me, Papa. Para 29, please show me what is the
But the
conclusion of the
apex
Supreme
court
Court.
has considered that if managing the business, someone should at least 25,000 for the managing the business. And
Where is the
consider-
evidence? Where is the evidence?
Lordship.
LCR आया? PCR आया?
No.
नहीं है.
Lordship, when it comes to page 7 of their application, the head income of the deceased starts with para 12.
Para 7?
Page 7
Ah.
of the judgment, improved judgment. Para 12, the head is income of the deceased. Kindly consider that.
Para 7?
No, Lordship, page 7,
Ah.
para 12. Under the heading income of the deceased.
Correct. That's why they produce that's what I'm telling. The income certificate shows the 6,42,000 the annual income.
But Lordship, court did not take 6,42,000. Court took less. And why less, I'll explain when.
Lordship, page number 33. 30.
In para 13, Lord, you will find court has taken 5,70,000.
Para page 33.
Page 30 starts from
33.
30.
30. Yes.
Evidences started from 30.
Whose evidence?
Anirban Rai. Justice.
Anirban Roy is the judge. Nilman Burman. He is the
Witness number one.
claimant.
Yes. Nilima Burman.
Nilima Burman.
क्या चाहिए स्टे का है तो दिया है तो
No document, only this thing.
ऐसा नहीं हो सकता मैंने दिया होगा
देख
हमें पास एक्स्ट्रा कॉपी है
Yes, kindly come to the I, page 30 I. One income tax
Return
return
certificate.
certificate, assessment 17, 18, 18, 19, 19, 20.
Yes, Lordship.
Then where is that certificate? Where is that exhibit?
The proper, Lordship, the proper way was to calculate, to take all the 3 years income and make a the thing.
Average.
Average. But the court has taken the lower side only. Of 2019-20, in between the accident happened and his income deteriorated. That has been taken by the court.
You have to prepare
Income
the-
tax return page number 80.
You have to file
Lordship.
the paper book. If you want to argue the matter on merit, then paper book. Where is the document? TCR is not there.
That's why last date I have submitted that to Lordship kindly grants liberty to file paper book. Lordship.
Paper book. You are arguing on merit,
Yes,
then
Lordship.
merit the total evidence and the cross-examination is to be
This is
taken, whether
required.
now whether you are arguing that has been taken in the cross-examination.
Nothing, Lordship, nothing.
At the time of
Even-
cross-examination of the claimant wife or whatever it may be, have you taken that plea?
That I was,
What income you are getting now?
I was showing Lordship para 13, where they have admitted my income.
The petition is directed on the trial court trial court record may be called for. Full list of the petition directed to file the requisite number of paper book within a period of 4 weeks. After supplying the copy to the learned counsel for the opposite party, liberty to mention.
48.
48, my lord, I am for the appellate insurance company, my lord. On the last occasion, my lord, have directed the department to ensure, to give a record whether I have deposited the entire awarded amount, my lord. Last occasion, I have given the challan numbers also.
How much amount you have deposited?
My lord, in total, I have deposited 94 lakhs 81,734.
Yes, that is there. Okay, it is there. You have deposited.
Yes, my lord, the
94.
paper book is also ready. Only thing is, my lord, in another case, my lord has given me the liberty to make an application that Reliance General Insurance Company, the name has been changed to Indus in General Insurance Company, my lord. Give me kindly 3 weeks time to file that application and then the hearing can be done. Paper book also has been filed. Paper book is ready,
The
my lord.
counsel, the officer submitted report wherein it find that the appellant has deposited an amount of rupees 94,54,734 by way of 2 checks, being challan number 11 dated 25th April 2025. It is further reveals that the appellant has further deposited the statutory amount of 25,000 by challan number 52 dated 31st of January 2025. Counsel for the appellant submitted the paper book is ready, but due to merger of Reliance General
Reliance-
Insurance Company with the
Indus in General Insurance Company.
Indus Ind General Insurance Company. Indus Ind General Insurance Company. According petitioners is given liberty to take appropriate steps for correction in the cost title of the appeal and
My
connected
lord, I
application
will
if
file
any
an application, ma'am.
within a period of 3 weeks from date. List the matter after 4 weeks.
I'm grateful, ma'am. I'm grateful.
Next.
49.
Yes.
Lordship, this is the MSC appeal, Lordship. Your Lordship had heard this matter yesterday, Lordship.
Yes.
This is
Who is for the insurance company?
Lordship, insurance company is not appearing for last
Yes.
2-3 occasions, Lordship. But then your Lordship's your Lordship has expressed your Lordship's mind that the minimum wage for unskilled labor it should be. So for that reason, I think they are not appearing, Lordship. Your Lordship had asked me for the notification of the minimum wages for unskilled labor. This is the latest notification of the state government, Lordship.
But unskilled labor 375.
375.
Yes. What he was doing?
He was a daily labor, Lordship. He was working in an agricultural field, and one tractor had fallen upon him, and he died, Lordship. And the appellant is the mother of the deceased. He was 20 years old, Lordship.
So why they are not appearing? Who is Devarshi Das? Dor?
He is Mr. Partho Bhomik was appearing for the
Last occasion when Dhor was appeared. Prior to
he
that,
had
none appears.
prayed for time on his behalf. I think.
None appears. None appears.
Partho Bhomik was it.
None appears for the appellant. Yes, what is the, only that one?
Only. No,
Only the
notional,
monthly income?
notional income, Lordship.
Only the monthly income?
Yes, Lordship.
And all are being given?
Everything is given, Lordship, but the notional income has been considered as 5,000 rupees.
What, where is our evidence?
Lordship, page 15 onwards is the examination in chief of the appellant, Lordship. Page 15 onwards.
Where you mention what he was working? I said that my son was working at the cultivation fields for cultivation of the coffee. Cultivation field to whom? In his field.
No, Lordship, not
Then
his field.
Where is the evidence? Where is the claim petition?
Claim petition starts from page 1, Lordship.
Page 1.
Lordship, first page, column number 4, occupation of the person injured dead, agricultural labor.
Agricultural labor. Where is the annexo? In whose field he was working? He has not been examined.
Lordship, he was the owner of the vehicle. He was the owner of the field, but he was a party in the claim application, but
Who was the party?
he did not appear, Lordship.
Who are the party?
This Mokleshwar Rahman. It was ex-party, Lordship. He did not appear in the court.
Owner has not appeared.
No, Lordship.
You have a judgment?
Judgment starts from page 50.
No, you brought the judgment of Supreme Court.
Yes, Lordship.
Where is that? Which one?
Lordship, this is the judgment of Aruna Devi, Lordship. Kindly see
Give.
last paragraph.
Daily I got Supreme Court. You persons are not reading the books and nothing.
আরেকটা judgment ছিল। Pronounce it ঠিক হবে।
Which paragraph you are relying upon?
Lordship, paragraph 22.
There's any paragraph 22?
Lordship,
I don't think so. 18-page judgment. 18 paragraph judgment.
Lordship, page 2, last paragraph. Page 2, last paragraph. The underlined portion. May I read, Lordship? The most reasonable basis for determining the loss of dependency, even in case of a minor, would be the minimum wages notified by the state government where the minor resides at the time of the accident, as the notional income is being determined on the basis of the minimum wages.
The petitioner has filed the present appeal being aggrieved and dissatisfied with the judgment passed by Motor Accident Claims Tribunal, Second Fast Track Court, Jalpaiguri, in MSC case number 365 of 2020, within bracket Bulbuli Necha versus Makaleshwar Rahman and another, dated 29th of November 2023. The petitioner has filed the present appeal only on the ground that the learned tribunal has considered the annual income of the deceased as 5,000. That is rupees 60,000 per annum. He submits that the learned tribunal ought to have considered the notional income of the deceased as per the Minimum Wages Act as unskilled Mazdoor. But instead of considering the same, has considered the annual income of monthly income of rupees 5,000 without any reason. Full stop. Learned counsel for the petitioner submits that the deceased was working as a Mazdoor in the cultivation field. And as such, the income of the deceased is to be taken into consideration as unskilled Mazdoor. He has relied upon the circular issued by the government of West Bengal with regard to the fixation of the minimum wages, wherein for the unskilled Mazdoor, the minimum wage is fixed at rupees 375. He submits that if the wages of unskilled Mazdoor is taken into 375, the monthly income would be rupees
9,760.
9,760. You're sure?
Yes, Lordship, it is written in the circular, Lordship.
375 into 11,250. 11,250. But the learned tribunal has taken into consideration rupees 5,000 per. The petitioner has relied upon the judgment in the case of Aruna Devi and another versus Ali Hassan and others, reported in 2026 SEC Online Daily 2174, and submit that in the said case, the Honorable Delhi High Court has held that the reasonable basis for determining the loss of dependency, even in case of a minor, would be the minimum wages notified by the state government where the minor resides at the time of accident. He further submit that in the said judgment, referring the said judgment, learned counsel for the petitioner submit that in the present case, the state government has notified the minimum wages of rupees 375 and per month 9,760, and as such the learned tribunal ought to have considered the minimum wages of the petitioner as 9,760. But the learned counsel for the petitioner perused the materials on record. In the evidence of the claimant and the police, the claimant is the mother of the deceased. The deceased was unmarried and was aged about Was 20 years. As per the evidence, the deceased was working as a daily wage worker in the private field. In the private field. Full stop. Though the learned tribunal has considered the monthly income of the petitioner of the deceased as rupees 5,000, but the learned tribunal has not assigned any reason why the tribunal has considered the monthly income of the petitioner as 5,000, and why the learned tribunal has not taken a notional income by taking into consideration of the minimum wages. Considering the above, this could find that the learned tribunal has heard in calculating the monthly income of rupees 5,000 instead of considering the monthly daily wages of petitioner, wages of the deceased as rupees 375 as per the notification issued by the government of West Bengal, and per month rupees 9,760. Considering the above, the award passed by the London Tribunal, London Motor Accident Claims Tribunal, Second Fast Track Court, Jalpaiguri, dated 29th November 2023, is modified only to the effect that the monthly income of the deceased is to be assessed as rupees 9,760. Thus, the annual income of the deceased should be rupees 9,760 into 12 kitna hoga? 9,760 into 12. 1,17,120. 1,17,120. Full stop. Adding full stop. Accordingly, the compensation of the appellant, is to be read as follows. Semicolon. Monthly income of the deceased assessed as rupees 9,760. Number B, annual income of the deceased 9,760 into 12 equal to 1,17,120. Adding 40% of 1,17,120 as future prospectus. Oh, what is that 40%? Huh? Equal to 46,848. List of number next. Less half as expenses of the deceased if he out to alive within bracket where he was unmarried, equal to rupees 23,000. 23,000. At how it can? 40%. Now the 40% will come. Adding 40% of the 1,17,120. How it is coming? 40% of the 1,40,000 as future prospectus within brackets 1,17,000. 81,840 equal to, so 1,17,000. 1,17,000 कितना है? 1,17,120 plus 80,000. 81,840 equal to, so 1,17,121 plus 18,000 equal to कर देंगे, ठीक है, फिर नीचे and then the 50% is to be divided to what is the total?
1,90,000.
Total 1,90,000 फिर नीचे into 18 into 18 equal to 35 lakhs. How it can be 35 lakhs? Equal into 18 कर देना हम देखने हैं. नीचे 5 adding general damage as per Pranacity. Number I, funeral expenses 15,000. Number II, loss of estate 15,000. Total general insurance and general damage 30,000. Furniture. Now the total income of the deceased plus general damage equal to rupees so and so plus 30,000 equal to देखने हैं. The with the above modification, FMA number 23 of 2025 is disposed of. Interest not given. The insurance, the opposite party insurance company is directed to pay the said amount along with the interest at the rate of 9% per annum from the date of application till the realization of the amount. Realization of the awarded amount. उसका ना यहाँ से देख लेना, देख लेगा ना.
My lordship, before rises, may small indulgence with regard to item number 58, 57 and 58, those are the admission of criminal appeal. Your lordship, on the earlier occasion, your lordship granted me liberty to file the special leave petition, which was ought to be listed in today's cause list. We have filed, but it was not listed today. Item number 57.
If it filed tomorrow, it will come.
Lordship, and with regard to item number 58, that is appearing first time.
Come tomorrow. It will be listed tomorrow.
Lordship.
Take up your pardon, my lord, with regard to item number 8 and 14, my lord, which order has been already passed, my lord. My lord, the opportunity may be given, my lord, to present my case. My lord.
No, already order dictated.
My submission can be recorded.
Okay, I will record, no problem. I will record. Item number?
Item number 8 and 14.
Office number.